Lawyers of Reddit, what was your hold it moment where you knew you would win? It was my third month of practice. I was in family law at the time, representing mom in a petition for a restraining order against boyfriend/dad. Point at issue in the broader case was child visitation, custody, support, etc. But today's hearing was just on the row. We had pretty good facts, but it was mostly based on testimony of the parties. My client was way more reputable as a witness, so I was feeling confident. 10 minutes before the hearing, my client shows up. I give her a last minute prep on what to expect, and then she says, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. "You have your phone with you?" "Yes." We play the voicemail, and it's a full 2 minutes of ex-boyfriend screaming shit, like I should have fucking killed you when we were together. "You were always such a bitch. I hope you burn to death in a fire." I didn't have time to ask her why the fact she hadn't said anything to me about the voicemail before the bailiff called our case. We sit. The judge asks if either side has additional evidence, and I ask for permission to play the voicemail. Ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole nasty 2-minute rant in open court. Judge goes, "We're going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they are welcome to." Boyfriend knew he was faked. We settled the whole damn case then and there. My client got a wish list in terms of custody, supervised visitation, child support, plus the restraining order, to boot. I'm a trial lawyer. I have a ton of these. My favorite was probably at a UI where the cop was in a BWW with my client watching a fight. Like, the cop was standing at the bar in full uniform, then when my client walked by him to leave, followed him out. Client was only actually going to his car to grab his phone charger because he was going home with the bartender. Like, he hadn't even closed his tab yet. Cop arrested him and charged him with DUI for opening his car door, then fabricated this story for his report about how client got in car, turned it on, and began to pull out of the space to leave the parking lot. He also denied being inside the BWW on the stand, under oath, to my face. Surprise. I talked to the bartender at BWW and got the security tape. It very clearly, like surprisingly good quality, "Don't try to steal from a BWW by the way," showed cop standing at the bar, watching my client walk out the front door, then follow him 30 seconds later. Parking lot cam also showed client barely touched the door handle before cop stopped him. Edit. Buffalo Wild Wings. I apologize lol. Edit too. Since a lot of people are seeing this, I'll add, the cop underwent an internal review, where the board determined he hadn't done anything wrong. A few months ago, he murdered an unarmed man while on patrol. He also trains new cops now, and tells young college girls he pulls over to call him Tommy. Bit of a soapbox. Cops don't need a reason to lie about what you say, do, or didn't say/do. I read hundreds of police reports, none of them are 100% honest. Cops lie under oath all the time. This story is just fun cause I got to prove him wrong and save my client from a conviction. If you are stopped by a cop for any reason, make sure you know your rights. Do not offer information. Do not consent to a search. Do not have lengthy contact without a lawyer present or asking if you're under arrest. Not a lawyer. Years ago I had to do something at a strip mall in a bad part of town. Took me about 20 minutes, and then I found that my car had been towed. Ubered to the tow yard. Giant sign says cash only. Had to call another Uber, drive to the ATM and back, and pay them $300 some bucks. Got a shitty handwritten receipt that, believe it or not, was itemized. Went home, googled, found that they violated the law in 3 separate ways. Towed illegally refused to accept credit cards, and had multiple charges that the law called unreasonable, like dolly fees and load/unload fees. Took them to small claims court. The judge began by asking the tow yard owner about his relationship with the property owner and how the decision was made to tow my car. "Oh, the slimy tow truck dude answered, my cousin works there. If he says tow, I tow. It's 100% legal." The judge's eyebrows begin to rise, but The dude continued, "But what I detest the most, your honor, is this asshole claiming I don't take credit cards. I'm a businessman. I take credit cards all the time. He's a lowlife that does not have any credit cards. That's why he wanted to pay cash." I was having a hold it overload, and the judge saw me smiling and hopping in my seat and patting my manila folder of receipts. "Do you actually not have any credit or debit cards?" the judge asked me. I pulled out my wallet and showed him, and then I pulled out a time-stamped photo of the cash-only sign I took the day of, and another one I took the morning of the hearing. The guy mumbled something like, "Okay, you got me there," and then had nothing but "huh." I didn't know that when the judge asked him about the legality of each unreasonable itemized charge. Anyway, each violation pays double the total tow charge. And since there were 3, that's how I made $1,800 on a $300 investment. But a friend of mine was a DWI attorney in New York for a while. He was defending a guy who was asleep in the backseat of his car while intoxicated, and an ICE trooper arrested him. On the stand, the trooper testified that he visually saw the key in the ignition. My friend gave him like 3 chances to walk it back. "Are you sure, trooper, that you actually saw the key in the ignition?" "Yes, counselor." When a cop calls a lawyer counselor, he really means asshole. And then my buddy dropped the hammer. "You are aware that my client drives a Toyota Prius?" Bam. Edit. 13 hours later, for all the people pointing out that there's a spot for the fob in the dashboard of some Prius models, etc., you have to understand that in a court of law, words have meanings. Ignition is most certainly specifically defined in NICE law as being what we all commonly understand as the ignition. The point is that the trooper, since their main duty is traffic enforcement on the roads, are expected to be experts on the cars. Also, he lied on the stand. He wasn't mistaken. He made it up and got caught. Yes, in New York, having the keys on your person while in the car is being under control of the vehicle, and thus can be arrested for DUI/DWI, but you can't sever the perjured testimony from the rest of the case. He lied. He got caught. My buddy moved for immediate dismissal, and the DA didn't argue. Case dismissed. Nothing happened to the trooper as to why the trooper did this. Promotions and overtime. Imagine you're running the entire New York State Police. You have about 5,000 troopers. What metric do you use to gauge how effectively they are performing their tasks? For the most part, troopers ride alone. So Trooper #1 drives around all day on his shift and issues 0 tickets and makes 0 arrests. Trooper #2 manages to issue, say, 5 tickets a day and makes a DWI arrest 4 times a month. You're going to assume that Trooper #2 is doing his job. An aggressive officer is one that has a lot of tickets and a lot of arrests. Also, court appearances are almost always on overtime. Police unions are very specific about overtime pay rates, and when they apply, if you're an effective trooper and you write lots of tickets, you're going to be in court a lot at 1.5 your hourly rate, sometimes 2.0 your hourly rate, depending. Also, Anil. Anil has long been internet speak for "I'm not a lawyer." I can't believe I'm about to use the "not a lawyer, but" loan, but here goes. Lol, tried to sell my home myself, and the buyers wanted a term period for land contract before getting their own mortgage. I agreed to 1 year, had a simple contract drawn up, and after we both signed it, everything seemed fine. Within 30 days they presented me with their own legally drawn up land contract that was pages long to protect their investment. About page 3 it very clearly stated that, if for any reason the home burns down, purchaser will receive all insurance proceeds. First, I still had a mortgage and the proceeds would legally go to pay that off. Second, that's a pretty targeted thing to say. Not lawyers' terms of the house being destroyed, and it's surrounded by woods and waterways, just if it burned down. Page 4 stated that this would remain a land contract until my mortgage was paid in full, so they'd never buy outright. I returned it to them with a letter stating those 2 things were never happening and I wasn't signing. They stopped paying, so I began eviction. 6 months later the lawyer I hired was an idiot, and I'm sitting down with their lawyer myself. He brings out the contract they'd tried giving me, and began talking about their ironclad case due to the agreement. I asked him to show me my signature. The look on his face when he realized it wasn't there. After we talked, it turned out he knew them and wrote the contract without the burn the house down stipulation. Seems they added it, and under the belief it was a long-term land contract. Not only did I win, I'm pretty sure they lost a lawyer friend. Not a lawyer. I was a volunteer family advocate. I worked with families who were falsely accused of child abuse. Part of that was going to court with them. I was contacted by a family whose children were in foster care because of parental drug use. The family claimed that they didn't do drugs and that no one would believe them. They had a court-appointed attorney who did nothing but tell them to stop using drugs. I honestly didn't believe them. I was pretty jaded. I told them to request their case file for me to review. I was surprised when they called me back and had the case file. I met with them and went through everything. I noticed claims of drug use, court findings of drug use, but no test results in their paperwork. I told them to ask for the results. Long story short, the caseworker wouldn't give them the actual results, and the lab wouldn't either. So, I drug tested them myself at a different lab. They tested clean. Color me shocked. There were 4 months to go until the next court date. Every time CPS drug tested them, they went right after to the other lab and did a second test. All clean. I told them to tell the lawyer beforehand that if CPS claimed any dirty drug tests, to ask in court for the test results. He didn't want to. I was starting to get mad. So, the day of court, I had a stack of clean drug test results in my bag. The lawyer wouldn't even look at them, and he was openly hostile to my presence and involvement. Court starts. I had been in this judge's courtroom before with other families. The CPS supervisor stands up and says that the parents have had 12 dirty drug screens in the past 6 months. The lawyer actually did ask her for the results. She said she didn't have them with her. I got the results out of my bag and handed them to the mom, who was next to the lawyer. She tried to get him to take them, but he ignored her. I got so agitated that the judge said, "Mrs. B's looks like she's about to have a stroke. What's going on?" I stood up and explained that we had clean drug tests taken immediately after the mandated ones that CPS claimed were dirty. I briefly explained that the parents had tried getting copies of their results and had been refused. I said that the parents had consistently denied ever using drugs and had clean tests to prove it. The judge ordered CPS to provide copies of all the drug test results at a hearing in a week. At that hearing, the case was closed and the children were released from foster care. The family never got an apology from anyone, but they were too traumatized to pursue it. They packed up and moved away within a month. So I filed the lawsuit in January. We exchanged discovery. Each side sends questionnaires and gets carefully worded answers over the next few months, and I file a motion for summary judgment, meaning I'm asking the court to let me win the case without a jury because the case is so obvious. Right before I file this motion, I figure let's review the discovery materials and see if there's anything I missed. And what do you know? The other side made a massive mistake on literally just the 4th out of 100 plus questions that I asked. It's a dog bite case, and every single time I asked about the bite, the response says something along the lines of "we admit to this and that, but we deny that our dog was involved in any dog attack." Well, question 4 asks whether they admit that their dog was not leashed on the day when it bit my client, and they simply answer, "admit." Meaning, they admit their dog was not leashed, and they admit that their dog was the one that bit my client. That was the one thing that was genuinely in dispute. They tried to argue at the hearing that it was a mistake and they only meant to admit to the lack of a leash, but the judge held them to their word, most likely because the other evidence made it clear it could only have been their dog anyway. Edit. For everyone hating on this for being misleading and the reason everyone hates lawyers, I'll clarify that at the time I wrote the questions, I would not have dreamed that they would have the balls to deny their dog's involvement. Their dog obviously was the one that did it. They let their dog out every day, no leash, and it terrorized the neighborhood for months, killing chickens, fighting with people's dogs, chasing cars, before it finally bit my client. It was the only dog that ever did this. And yet the insurance company tried to lowball my clients and refused to even cover their medical bills, so after 2 years of negotiating they finally lawyered up. I'm not a lawyer, but I've been up against plenty of them as a union chief steward. Years ago we had an arbitration related to healthcare costs. The company spent the better part of a year trying to break us from pursuing the case. The day had come for our arbitration. The lawyer, there were 3, actually, we were up against was actually Paul Newman's nephew. Anyway, it was my turn to take the stand. His first question to me was presenting the grievance as evidence and asking me what step it said it was on at the top of the page. Our grievance process is a 2-step system, progressing to arbitration. If it's not settled, I said second step. Then he smugly asks, and where is the first step? To which I replied the first step is a verbal discussion. It goes into writing at the second step. He looked hurt, but persevered anyway. A few more questions in he asked if the entire company got base level insurance instead of a premium option that would satisfy the contract. At this point he was hoping I would argue that the base level insurance wasn't sufficient because he was trying to paint the picture that we were just trying to get premium insurance at a base level price. I responded with yes. He looked dumbfounded. Asked me yes. I said again yes, that would satisfy the language in the contract. He kinda looked at his other papers he was going to submit as evidence, then muttered no further questions. I knew at that moment that they had brought no real argument to the table. We got our answer from the arbitrator 6 weeks later, during a contract negotiations meeting. It was insanely satisfying watching them read the email during one of the sessions, and the immediate shift in demeanor from their side of the table. They got real quiet. We were awarded 100% of the arbitration. Full back pay for all employees that were being overcharged, and reduced rate for the premium insurance. Not a lawyer, but a client. In my divorce trial, my ex-wife has spent about 2 hours explaining to the court what a pose I was and all the horrible things I had done to her and my children, and that I was unfit to be a parent. 2 solid hours. Lie upon lie. Just 6 months earlier, my wife had snuck into my house. She's the one who moved out and went on my computer to type me a love letter. Oh, you're so wonderful. You're such an amazing father, great provider, great husband. You've done so much for the community. Please don't leave me. That's the gist of it. Well, she didn't print it or sign. It was just a file on my computer, left on the screen for me to find. So our challenge, after all her testimony to the contrary, get her to admit she wrote this letter. I told my attorney, ask her. She won't be able to lie if she's sworn in. Plus she's going to feel incredibly guilty about all these lies. So he handed her a printout. He had one too. He started reading it. He asked her, continue the reading. She started to cry. He asked her, do you remember writing this letter? Her face was shriveling. She looked at her attorney and said, I'm sorry Sandy, her attorney's first name. Then she looked at the courtroom and said, yes, I wrote this. There was silence for a few moments. Then the judge said, attorneys, in my chambers. Now, my attorney told me later, the judge understood that when your wife said I'm sorry Sandy, that meant that her attorney was aware this letter might be brought up and that she had instructed her client to lie. The judge was furious. Back in the courtroom, my attorney went down the list lie by lie. Did he really do this? Did he really do that? When you say he was doing this, wasn't it really that? etc. Then he had her read the entire letter again. After that, my divorce went from me being 1/2 inch away from losing all custody and relegated to supervised visits to I got full custody. Made 40V, or what? Bought a hurricane door from a contractor that was found through our state's hurricane readiness website. He took $5K, and after about 3 weeks of car or scheduling issues, finally just ghosted us. Took him and his company to court. The him and his company part is important. Finally court day shows up, and I'm fairly young and optimistic, so I figure I don't need a lawyer. Plus the local news station took my story and came out to interview me to do a bit on it. I figure it is a fairly obvious case, easy win. I put on my best, only $99 suit and head downtown. Dude doesn't show, but instead sent his company's office manager. We get settled in with the arbiter. First thing I was wrong about. Oh sheet, not court with a judge and sheet. And the office manager starts in that they deny my claims and in fact are countersuing me for cancelling the contract. I start to sweat, like oh sheet, they're going after me. What happens if they believe them? I'm going to be out 5k and have to pay them more. FML. Point. The arbiter listens to her and then asks me to tell my side. I told him, plus showed documentation of what I had did, and when arbiter dude looks at her and says he has enough to prove you wrong by even if he didn't, because your boss Michael blah blah couldn't even be bothered to show up when he himself was specifically named in the suit. I'm ruling in the plaintiff's favor. Cue me trying not to happy dance or look too smug before I got out of that room. Side note, just because you win a judgment against someone, that doesn't mean you will get paid. You still owe me $5k Michael. I represented an elderly Indian couple who didn't speak English very well and owned a rental property. They had a tenant at the time who had not paid rent in over 6 months. They had tried to evict her on their own, but when they got to court, the tenant produced some handwritten notes which they had given her the year prior thanking her for payment, but they failed to date the notes. Of course, the tenant added recent dates herself. The tenant also produced a partial certified check receipt, but most of it was illegible. Anyway, because of their poor English, they had difficulty understand the questions and giving intelligent answers, so they lost the initial case. They hired me to help address all of the various lies that the tenant was putting forth. Anyway, we refiled. I had my clients pull the banking records so we could show the date that the certified check was actually deposited into their account. The plan was simple: let the tenant make the same arguments and then present the banking statements showing the deposit date. My clients also found a photocopy of one of their notes, but it was undated, unlike the copy the tenant presented the last time. Well, when the judge finally understood that the things the tenant had presented occurred the year before, his cheeks turned bright red and he asked the tenant, "What year did you make this payment?" The tenant started saying something like she couldn't be exactly sure when, and the judge cut her off again in a very loud voice. What year? Needless to say, the clients got their eviction granted. Bonus content: when the tenant arrived at court, I watched as she got out of her car, walked to the back, and pulled out a wheelchair, and proceeded to stay in that wheelchair until the case was over. Once the judge left the courtroom, she folded up the wheelchair and carried it to her car, mumbling that she hates ing lawyers. Anyway, that was a very satisfying day. TLDR: plaintiff's attorney forgets to send notice to my client to testify. Can't make $35k case with his she-eat witness. Gets smacked down for not knowing local rules. I did a quid pro quo case for a guy who was doing my firm's website. It was a breach of contract case for a credit card. The debt had been sold, and at the time of trial, the ad danum was something like $35k. The client brought me in late in the game. He's already gone to mandatory arbitration and lost. I get the case a week before the bench trial, and when going through the pleadings, etc., I realize that the plaintiff never sent a 237 notice. This is when one side tells the other that they need to make available either tangible evidence or a party witness at trial. Think subpoena, but less bite. So the plaintiff forgot to send this notice to the defendant that he needed to appear at the trial. Normally, if a defendant doesn't appear at a civil trial, you get the obvious: the judge only hears one side of the story and definition loses. When a 237 is given, and the defendant doesn't show, the judge is supposed to infer that definition didn't show, because his testimony would have hurt his case. Negative inference. But, because this was a debt buyer, plaintiff had no actual knowledge that this credit card bill and charges belonged to my client. All they get is a single page printout from the original debt holder saying they sold this debt, and if they're lucky, some copies of statements. They could easily have proven it by calling my guy as a witness. Even if client denies charges, plaintiff can make a good case because defendant's name is on the bill, it's to his address, the restaurant charges are for the sub shop on his block, etc., and all that would come out when the call definition as a witness. So, I tell my guy wait down the street. We do pre-trial motions and plaintiff asks for my client. I point out their procedural error and they panic. They put on their witness, who is some account rep at the debt buyer, and I object to hearsay on everything they try to get in. She has no knowledge, can't lay foundation for statements, and the only thing she can remotely testify to is her own business record, the single page showing a debt sale. Not enough. Then plaintiff attorney gets a bright idea. He starts to ask his witness about the arbitration hearing. I see where he's going and let it play out a bit. He's trying to get in an admission of party opponent. Basically, witness can say that at the arbitration hearing, my client admitted this was his debt. But this is an out-of-town attorney. He doesn't realize that, because arbitration is mandatory and has very relaxed evidentiary rules, all evidence comes in if you tell the other side what you're going to use, that this county considers arbitrations to be the equivalent of settlement conferences and the testimony isn't admissible at trial except to impeach. Result, directed finding for my client, who saved himself a $35,000 judgment. Judge praises my defense, and I get to make super fake small talk in the tiny elevator with the plaintiff and his witness after trial, where I walk out to hand my client the court order in his favor. Most satisfying win ever. I was testifying for the defense. A young man had been arrested for assaulting a police officer, allegedly throwing bottles during some unrest in Oakland following the verdict in the trial for the cop who shot Oscar Grant in the back on the BART platform. I had been there filming stuff, caught his arrest on video, and his brother found my footage on YouTube and asked me to testify. I had only seen bottles being thrown from this one corner of a parking lot, from behind me, with the bottles flying over my shoulder. The defendant was in a group in front of me point on the stand. The prosecutor seemed to think I knew the defendant and was there basically committing perjury on his behalf. I explained why I had been there that night, that I had never seen this guy before, hadn't been coached by the defense, and hadn't been paid other than a small amount for my travel and time. Finally, exasperated after much back and forth, the prosecutor says, "Well, if you don't know the defendant, then why are you here testifying for him?" I thought for a moment and said, "I guess I just wouldn't want an innocent man to get convicted for a crime he didn't commit." He got visibly flustered and quickly moved on, trying to insinuate that if I didn't know him, how would I have known to be looking in his direction to see whether he was throwing things? And I tried explaining that if you're looking at a group of random people and one of them throws something, you will naturally fixate your attention on that person. But because nobody in that group threw anything, there was nothing to notice in the first place. It looked like the police just grabbed him at random point they rested. The defense attorney bought me lunch down the street, and then he got a call from his colleague that the jury took all of 10 minutes to return a not guilty verdict on the assault charge. They said my response was legendary though, and that no attorney should ever ask a question they don't already know the answer to. This guy just seemed to have a narrative about a prior relationship to the defendant that he assumed was accurate and was trying to call my credibility into question. Misdemeanor trial defending a guy accused of third-degree assault on his girlfriend. She had a bruise on her neck and told the police that it was from my client strangling her. Somehow it got around the public defender's office that someone overheard the victim admit to her mother that it was a hickey. She was on the stand, and she was terrified. I kid you faking not, I had the Tom Cruise standing there struggling whether he should accuse Nathan Jessup of ordering the code red moment. I was battering her with answers, not open-ended questions, as it should be. It also helped that I had a projector slide up on a screen in the courtroom of massive butcher knife stuck in the wall. Yes, she threw it at him. I had her admit that, but that wasn't the clincher. It was the moment when I honestly decided, while standing in the middle of the courtroom, whether or not to assert that the bruise on her neck was a hickey. I didn't know if it truly was at all. I mean, it was hearsay within hearsay with a double smattering of more hearsay. But I wasn't going to assert it as if it was overheard. I was going to assert it as a fact. The trouble I had with the decision to go with this was that what if I asserted it was a hickey and she says no, I got that from him strangling me? Then I look like a massive idiot and it only bolsters the DA's case. I literally said fuck it in my head and said, "And isn't it true that the bruise on your neck is a hickey?" She breathed out, slumped in her chair, and eked out a yeah. I thought I was faking Vince Lombardi. We won. Not a lawyer, but just a very observant girlfriend. My boyfriend's car was involved in an accident. He was parked in an area where during certain hours you were not permitted to park as it would block semis from being able to maneuver to deliver goods. It was a steel plant. A girl backed her vehicle in his driver's side door of his Ford Fusion. Cops were called for insurance purposes and my boyfriend states that it appeared the cop and the girl knew each other. They were on a first name basis. He received a parking ticket. It took forever for the insurance companies to sort it out because she didn't think she was at fault because he was parked illegally. That doesn't matter or make legal for you to hit someone's car and get off scot-free. She ended up having to pay for his deductible point, and this is where the harassment from the local PD began. He received a piece of mail from our magistrate stating he failed to pay a parking ticket and a bench warrant would be issued if he didn't pay it, or he could request a hearing regarding the ticket. He was just going to pay it. I looked over the paperwork and found that the vehicle they said he parked illegally was traded in before the ticket was issued. The ticket indicted a white Toyota Tundra, but the license plate block was not filed out. It was signed, but you could not make out the badge number. We had traded his Toyota Tundra on a Ford Fusion in December. The ticket was written in Feb of the following year. I was pretty pissed. I gather all the evidence for him, trade-in paperwork, and he went before the magistrate. Cop testified that he saw a white Toyota Tundra illegally parked at a certain location that had a parking time restriction, and it was owned by my boyfriend. When he ran the tags, I should note that my boyfriend had had several parking tickets while he owned the Toyota Tundra. That's a guess on how he got just enough info to write the ticket. My boyfriend presented his evidence and the judge dismissed the case. The judge was heard to say to the cop that he would like to speak to him afterward and chastised him for wasting the court's time. The cop later told me boyfriend that had he contacted him, they could have taken care of it outside of getting the magistrate involved. Needless to say, we haven't had an issue since. Not a lawyer but self-defended myself against an utterly bullshit charge of using my cell phone, which was turned off charging while driving. When the cop pulled me over and said it was because he saw me using my cell phone at a light, I told him that was impossible. It was turned off and I would happily turn it back on and show him it hadn't been used in over 10 minutes. He refused to see it and wrote the ticket. $590. I was pissed. I'll own up, if I make a mistake. I once got a ticket for going 81 in a 60 zone that I thought was an 80. I didn't even fight because I was in the wrong, even if I wasn't knowingly speeding. But this was complete crap. I didn't really think I had a chance, but hoped the cop wouldn't show. My luck, he did, and then the prosecutor showed me his statement. He lied and said I told him I had just been checking my messages. Well, when he pulled me over and I told him I'd show him my phone, I took screenshots of my call list, my email account, and my text messages, all of which showed the time of the screenshot and the last call/email retrieval/text sent or received. Judge let me admit them as evidence because his statement specifically indicated I admitted doing something relevant to the screenshots. And they of course proved that I had not used the phone for any of those things. Strike one against him. Then, when he testified, he said that he had seen me pull my phone out of the cup holder, look at it, and put it back in. My phone was on a dash mount when he pulled me over. So I asked him about the cup holder, and he said it was dash mounted. I actually had a picture of the interior of my car because I thought maybe he's seen me touching the screen of my car's controls. I drive a Prius, so I'd taken a picture of the interior. That of course showed the cup holders are not on the dash and instead are in a console in between the driver and passenger seats. Strike two against him. Finally, I produced my cell phone records that showed I owned an iPhone 6 Plus at the time of the ticket. I asked him again if he was certain I'd put it in a cup holder, and he said he was. He could hardly change his story on the stand. So I took a cup that was on the desk in case people needed water during the trial and set it and my phone in front of him and asked him to try to put my phone into the cup. 6 Plus phones were huge and I use an Turbox Defender. There was no way it would fit in a cup holder. He glared at me and said, well, the cup holders in my truck are big. It would fit in them. I reminded him the ticket showed I drive a Prius and they are not a big car. Third strike. 3 times I proved that what he said could not have happened. The judge at this point interrupted. She said at the start she would provide advice since I was representing myself and that was part of her job, and said I'd made my point and did it very well. That was when I knew I'd won. And boy was that cop pissed. But it was a glorious moment for me. not a lawyer, but represented myself in small claims court. I bought a motorcycle while working overseas in Afghanistan. I had my brother-in-law pick it up with his trailer, hand over the cash, and get a bill of sale for me. I came back home a week later, so I was able to have all the paperwork for the DMV in my name. Anyway, in New York State, you can sell a vehicle that has a lien on it with a lien release. In NJ, where I lived, you just can't do that and need to get a new title with no lien on it. A lien release letter didn't matter. Well, this one was the original title from a decade and a half previous, which had a lien on it from the credit union that loaned the money to the original owner to finance the motorcycle. It was paid off, so I just needed a new title without the lien on it, so I could transfer the title and register it in my name. The problem was that the credit union had been absorbed by another regional bank, and they couldn't provide the new title to me because I wasn't the borrower. They could only provide a lien release form, but that didn't matter to NJ. It made sense because I didn't have the business with them. So I go back to the owner and ask them to please get a new title without a lien on it. This dude sends me the lien release, and I told him again I needed the new title, not a lien release. Phone calls and emails go back and forth for 9 months until his girlfriend, using his email, said, "Jimmy said that it's your problem and he don't want nothing to do with it." I'm sorry. I told him that's not right. I responded and then got a curse word laden response from the guy himself telling me he did what he was supposed to and I needed to fuck off. So at that point, what could I do? I had the bike with insurance, but it couldn't be registered in my name without the title being in my name. I drove the 90 minutes to his hometown and filed paperwork with the clerk to sue him on small claims court. The bike cost $3,500 and the maximum was $3,000 in small claims court, so close enough for me. The court date approaches. I figure he wouldn't show up, but he did. And he was wearing a muscle shirt and cute off jorts, while I was wearing a shirt and tie. I present the case to the judge. This douchebag defends himself and said it was just a misunderstanding and that he didn't realize he had to get me corrected paperwork. The judge says, well, since this appears to be a misunderstanding, and that's where I interrupted him. I explained how he told me to fuck off and he was well aware of everything I needed because, as you see in these printed out emails, the highlighted parts show where I was very detailed and specific with what I needed, and the other color highlighted parts were where B acknowledged my request and told me to fuck off. The judge's face changed instantly. He changes his tone and immediately says, I rule in favor of the plaintiff for the sum of $3,000 and ownership of the bike. He then addressed me directly and said, by the looks of this guy and his address within the village, it was a trailer park. I assume he doesn't have the money and the only way we can enforce it is to put a lien on his property, which he will never pay. What I can do is adjourn for now, and if you don't get the title 2 weeks from now, call the court and the judgment will be made in your favor. 8 days later, I had a title in my hand with no lien on it, and I could finally register and ride my bike legally after having taken possession of it 11.5 months earlier. Maybe this belongs in revenge. Right after I got my license, but before I had a job, I volunteered in landlord/tenant court. Basically the first case I ever took to an evidentiary hearing. The landlord was trying to terminate the tenancy, meaning they didn't care if they got rent money, they just wanted the house back. The reason cited for termination was non-payment of rent. That's odd because most landlords would probably file a non-payment of rent case, but it's also a lease violation, so they can legally proceed with the termination. My clients didn't want to leave, they just wanted him to fix things, so we went to trial. Losing meant my clients had 10 days to move to prevent an eviction. If clients had filed non-payment of rent, my clients could have prevented eviction by paying the rent. These cases are summary proceedings, which for me means, if we can't settle we will immediately go to a bench trial, where my only evidence is what my client brings with them. The case had already been adjourned once, and I only met my clients minutes before the hearing was scheduled to start. I made one pitch for a settlement offer and the landlord basically refused to talk to me, so I had to make my case up on the fly, which might happen in movies, but isn't supposed to happen in real life practice of law. Thankfully, we were the last case on the docket and there was a union-mandated lunch break for the court personnel, so we were on the record for only about 10 to 15 minutes before we recessed, and I had an hour to come up with a plan. There were no technical problems with the complaint, so my only argument was that the termination was retaliatory. That was a tough case to make, because technically the law only specifically protects the tenant from retaliation for calling a government agency, which my clients hadn't done, so I'm trying to convince the judge to interpret the law against retaliation broadly. It probably won't work, unless I can convince her the real reason the landlord wanted to terminate the tenancy was broader than just non-payment of rent. The landlord brought in his handyman as a witness. His testimony was basically that my tenant's complaint about the property were frivolous, and that the house was in good shape. The only good tidbit I got from his testimony was that the furnace was installed incorrectly before he was hired and fixed it. So my client's complaints weren't entirely frivolous, but this was now the middle of summer and the furnace now worked just fine. And now that he was the handyman, according to him, the house was in beautiful shape. I tried cross-examining the repairman, and he turned out to be tough for me to control. I'd ask yes or no questions which he'd supplement with very technical explanations for how the furnace worked. He kept saying he took the tenant's complaints personally because he felt they were attacking him personally for doing a poor job, and the reason he wanted to testify was to defend his work. I knew he'd be called to the stand again, but I decided not to cross-examine him any further the second time because he was such a good witness and too hard to control. He foreclosed the possibility of me making the case simply listing the repairs that needed to be made. I didn't feel like it was going well for me until the landlord himself took the stand. The judge posed some questions. Again, this is summary proceedings, so trial procedures are a little different, and to one he said he wanted them gone because he was tired of them always complaining. Once he said that I immediately knew I had him. That's what I needed, an admission of his mental state when filed the case. My cross-examination was entirely focused on his frustration with them always complaining about repairs. He hanged himself with his own words. The judge wasn't very sympathetic to him because the landlord has a duty to keep the house in good repair. Because he said on the record that the reason he wanted them out was because they kept asking him to do his job. She held the eviction was retaliatory in nature and dismissed the case. Was defending my client on a felony family violence assault case. My client and his girlfriend had been in the car together, and she claimed he beat the shit out of her while he was driving them around, speeding, drunk. She had even called her mother during the drive and made an outcry to her on the phone that he was punching and hurting her. She said he caused 2 wrecks and he broke her nose and busted her head open. My client denied it all and was promptly arrested by the police. She told a great story at trial, which was well received by the jury, until I played the cell phone video my client had taken during the drive, which showed that she was driving, that she was intoxicated, that she caused the first wreck, then drove off without stopping, and that she blew through a red light and caused the second wreck. And it showed that, while she was calling her mother and screaming about him abusing her, he was calmly sitting in the passenger seat, looking blankly at his phone, not moving, begging her to stop the car and let him out. The judge stopped the trial, thanked and excused the jury, and erected a not guilty verdict for my client. He then had the girlfriend stand up, and he Mirandized her, telling her to find a lawyer to defend herself, as he would be recommending perjury charges against her to the district attorney. My guy had been charged with assaulting the same woman 3 months before, and then charged in another county with violating a protective order she had out against him, and we used her perjury at our trial to get the other charges thrown out. And yes, my client was a moron who continued to date this woman. While I'm a lawyer, I was observing this occur. There was a moment during cross-exam I knew the defendant won, and it was absolutely lost on the witness. The defendant was given a ticket for not placing a flag on ladder that was extending beyond the bumper. The law said that there had to be a flag at the end, usually a tie drag or something, of an item being transported, if the item extends 4 feet beyond the back of the vehicle. The officer testified that he pulled the truck over, driven by the defendant. The officer measured the length the ladder was hanging over the tailgate with a tape measure, which was 4 feet and a couple of inches or so. There was no flag. The prosecutor had no further questions and the defendant, who was a painter by trade, not a lawyer, did a brilliant cross. The tailgate was closed, so the ladder was hanging over the tailgate at an angle. The tops of the ladder was lower than the bottom of the ladder, which was hanging over the tailgate. The defendant asked the officer at what degree the ladder was to the bed of the truck. The officer did not know, but estimated 30 degrees. The defendant asked the officer to do trigonometry on the stand to calculate how many feet the ladder extended linear to the bed of the truck. The officer was not understanding that, while the ladder was 4 feet and change over the tailgate, the angle the ladder was sitting made us under 4 linear feet away from the back of the truck, which was the law. The officer kept arguing with the defendant. The judge finally stepped in and said that the state had failed to meet its burden of proof because there was no proof the ladder extended 4 linear feet behind the truck. Point was absolutely brilliant defense. The officer had to be shown a diagram explaining why he was wrong to give a ticket. Not a lawyer, but I entered an intersection on yellow going straight. I did not change my speed, since I thought I was too close to the intersection to safely brake point in the oncoming lanes. A car waiting to turn left, thus crossing my right of way, entered the intersection on yellow attempting to make it to the interstate in rush hour traffic before the light changed to red, a well-known long red. I saw him and swerved a bit to avoid what I could, but he still hit me, my rear driver's side, his front driver's side, and caused my side curtain airbags to deploy. To add insult to injury, the tow truck then burned my brakes because they towed my car 30 miles with my parking brake fully engaged after the accident. Point other driver told the officer that he thought I was going to turn right onto the interstate, what most cars do there. But I was in the left lane, which doesn't turn right, it only goes straight. My destination was in front on me, not up the interstate. I didn't have a turn signal on either, so even if I was in the right lane it would have been clear that I was going straight, not right. Point anyway, the responding officer gave us both tickets because he said we both had a duty to stop on yellow, which is not what driver's ed taught me, since driver's ed said you have a quick decision if you're close to the intersection and have right of way on yellow. He also orders us to both show up in traffic court. Point meanwhile, we had the same insurance carrier. Insurance got statements and images from both of us and ruled that the accident was completely the other guy's fault, so he had to pay all the insurance fees on such point. When I got to traffic court and the officer called my ticket before the judge, and the judge asked for my plea/response, I instead politely asked if I could ask a question before we begin. Judge and officer seemed surprised, but agreed. Point I then said that there was another vehicle involved, but that I hadn't seen the other driver in the courtroom yet. Judge asked if this was true. Officer checked his notes and confirmed there was a second driver. Then court confirmed the other driver was a no-show. They then did something to call for a penalty against the no-show guy. Then I said that the other driver and I had the same insurance provider, and that our insurance provider had ruled the missing driver at fault and repairs to my vehicle were even underway at his expense. I had the insurance claim info with me. Point judge and officer exchanged looks. Finally, I asked if, given that the insurance company got the same evidence already, decided I wasn't at fault, and the other driver was missing, if they would consider dismissing the charge outright. Judge and officer chat and then tell me to sit down and that they'll return to my case a bit later in the day. Point court then handles the rest of the officer's traffic cases for the morning. Officer comes over to me afterwards and says all charges are dropped as long as I don't get another ticket within 6 months. If I get a ticket, this case could come back for discussion. 6 months pass. I call the records in court and they confirm no charges, no points on my license, and no outstanding fines. This will get buried in the sand, but when I was in college, I bought a new motorcycle. I didn't yet have a motorcycle license, but I was riding around getting used to the new rocket when I got pulled over. Cop was nice, let me ride home, but I had a ticket and was bummed. I completely intended to pay the fine and move on and try to find a motorcycle buddy that would ride along to get me to the DMV to get my test done and license in hand. I talked to my roommate who was pre-law and had a father that was a lawyer. He sent a copy to his dad to look at and his father called asking for me to talk through what happened because he was confused with my ticket. It turned out, the university officer that pulled me over wrote me up for driving on a suspended license. When my buddy's dad realized the error, he told me take it to court and plead not guilty. Then at your court case, don't say anything until towards the very end. Then when the judge asks if you have anything further, say yes, Your Honor. I would only like to say that this ticket is for driving under a suspended license, and I can prove my license is not suspended. That's exactly what I did, and since the cop was represented by himself, and presumably an intern, they just sat there fumbling through papers not able to do anything. Finally, and this was the best part, the judge turned to the cop and said, I don't even recall how many times I've had you in this courtroom with erroneous tickets. Get your sheet together, or find a new job. That, kids, is how I got out of a ticket. I'm arguing a motion for summary judgment in front of a judge who has never ruled my way on anything ever. I was expecting to go home with nothing. He's holding the hearing in chambers, so we are all sitting around a conference table. I make my arguments and say, and I have 6 recent cases all supporting this. He says, and you brought cases. That's amazing. I thought he was being sarcastic, and he was, but not for the reason I thought. While I thought my motion was dead in the water, he was a step ahead of me. He didn't need to see my precedent. I finish my 10-minute presentation, and then it's opposing counsel's turn. She starts arguing, and when she's done, I say, may I have 1 minute for rebuttal? The judge says, you're not gonna need that, and just like that it clicked. He was ruling in my favor. In fact, he'd known all along my motion was solid because he'd read it. He denied my last 2 motions on discovery matters because he knew where this case was going. He knew he was going to grant summary judgment and there was no point. He granted my motion and that was it. I won the case. No trial necessary. It's rare to get summary judgment in my area of practice, and I was stunned. Excited, but stunned. That was my last hearing with him before he retired. It made me rethink how I size up judges. My expectations were completely wrong, and I should have given him more credit walking into the hearing. I represented myself as a 17-year-old kid in traffic court. Contested the ticket hoping for the cop won't show for the court date, and they'll throw it out trick. Ticket was for tailgating, following too closely, while executing a left-hand turn at a light. Cop showed for court date. Oh shit. Judge called me up, and cop is on the witness stand. Cop starts giving testimony sounding super official, because he's a cop. Times of day, badge numbers, road conditions. Says my speed was approximately 12 miles per hour. Point of view angles. Recollections of questions to and answers from the driver. Floaty head, surreal out of body type feeling ensues as nerves kick in, and I have no idea what I'm doing. Judge thanks officer professionalism for his testimony and asks if I have any questions for the officer. Oh seat, I have to talk. I ask, how fast was the car in front of me going? He answers, approximately 15 miles per hour, head rush. I've got this, Your Honor. How could I follow too closely a car that was moving faster than I was and therefore pulling away from me? Judge laughed, thanked me for taking the time to represent myself, and thanked me for respecting his courtroom. I had dressed really fancy for a 17-year-old. I think a suit left over from my grandpa's funeral. Judge threw out the case and dismissed us both. Cop walks out from a side door as I walk out of the courtroom. Totally expecting him to be a dick. He shook my hand and thanked me for keeping him on his toes. Told me I did a good job. There is nothing more satisfying than as a defense lawyer in a bail application, getting police to admit that they didn't take any steps to check the obviously unwell suspect's mental and physical health history or obtain treatment once arrested, contrary to the police manual. Actually, anything where police haven't followed basic protocol is fun. The police manual says you must do this. Yes, did you do any of those things? No. But the best moment I've had in court was getting a repeat DFV offender to admit that he was an abusive, violent man who thought he was the victim. You an abusive person? No. Were you convicted last year for threatening and abusing fisheries officers? Well yes, and were you convicted of assault in 2013? Yes. And was the victim of that assault the applicant for this domestic violence order? Yes. Do you use threats to control or intimidate people? No. Remember that conviction for threatening Fisher as officer's mate? And weren't you just convicted 2 months ago for breaching a DVO against the applicant on the basis of threatening behavior? Yeah, but that was bullshit. etc. It was so much fun. I don't know why his lawyer thought tendering his prior criminal history would help. Presumably they thought he didn't have much DFV history. Instead it gave me a goldmine of cross-examination material which let me prove he was a habitually violent, threatening, abusive asshole. I know, but there was a time 9 years back where I defended myself in court. In the town I lived in at the time, a nice medium-sized city out of state from where I originally grew up, a monthly parking spot was around $200 a month, whereas if you parked on the street, a ticket was $20, and they only ticketed you 3 to 4 times a month. Needless to say, as a recently graduated college student at his first job, I opted to park on the street and pay the occasional small fine. One day however, I found my car towed to a different location, and having to pay an $80 fine instead of the regular $20 due to a special event. The $20 tickets, I would pay happily, but this $80 ticket in tow, that they didn't announce prior? No chance. Furious, I went to court, dressed in a suit vest, the full 9 yards. There I got the parking enforcement officer to say to the judge that he had looked up my plate, gone to my address, and knocked on my door to let me know my car was about to be towed. There are no words in the English dictionary to describe my joy I felt when it was my turn to cross-examine him and asked him specifically how long it took to get my out-of-state address from my out-of-state plates and let me know at my out-of-state address that I needed to move my car. He hadn't done that. All lies. Boom. Case 1. I had him, perjury, in front of the judge. Every ticket he has ever written open to examination because of his blatant lies. Except then, the judge asked me how many parking tickets I've received, and I had to truthfully answer 30 plus. And then he made me pay the ticket. TLDR, don't go to court unless you not only have a great case, but also minimal tickets prior to said court date. I was defending some small town police officers that were called to a rent house after a shots fired report. The trashiest family that owned the rent house was there working on it and harassing the neighbors, I think because the family was racist and the neighbors were black. Anyway, fam was acting the fool and responding officers had to detain them and do safety pat-downs to try to find the gun. Mom and daughter both made claims later that the officer groped them inappropriately on the pat-down point. I deposed both mom and daughter separately. I asked both if the other family members saw the alleged groping. Both said yes. I asked if both were groped the same way. Both said yes. I asked for a specific description. Mom said overhand rub down of breasts and buttocks. Daughter said cupped hand boob lift and butt lift. Both were insistent the officer did the same to the other plaintiffs. INCONSISTENCY equals NOT credible point. But the cake was when I asked if their hillbilly father/husband and son/brothers had done anything after witnessing their mom/wife and daughter/sister be sexually assaulted as they claimed, and they both said no. These idiots had kicked in the neighbors' doors, chased them around the yard trying to fist fight them, and shot at them for flipping the family off, but all of a sudden they get a case of the act rights? Had a dismissal from their attorney, filed that next week, after exposing his clients as liars who were just mad that a couple of their hillbilly family members got arrested. I was representing a business person who had leased a food truck to an individual that had filed for bankruptcy. My client repossessed the vehicle after failure to pay for several months, and normally this would trigger a violation of the automatic stay provisions of a bankruptcy filing. However, the debtor had signed the lease agreement under his name, doing business as food truck, and the DBA was registered under an LLC. The debtor tried to have my client sanctioned, and my client offered to settle the matter for $9,000, just to avoid any litigation by the debtor's LLC. The debtor later reneged on the settlement, hoping to squeeze more money out of my client, because he claimed that his food truck brand, which was moderately successful, and permits raised the value of the truck. I successfully argued that the branding was inconsequential to the actual depreciating value of the food truck. We offered to settle again after going to arbitration and he refused. The bankruptcy judge heard the case, and given that the debtor had flip-flopped over whether the truck was his or the LLC, and I took great detail in pointing out his conflicting stances, the judge ultimately came to the conclusion that my client hadn't done anything wrong because the truck was clearly under the title of his LLC, which is not given bankruptcy protections, and granted us retroactive relief. My client got to keep the truck, did not have to pay the debtor, and a small claims case for unlawful repossession will be going nowhere given all the stuff he said in the bankruptcy case and pleadings. So not only did the greedy debtor not get any money, he owes his attorney fees, and my client can still file a proof of claim for his attorney's fees and try to get his money back for the needless litigation. He has assets. He lied in his petition saying he had not been operating when he was, as well as other abuses of the bankruptcy system, and it's very likely that the trustee will be liquidating his home. Not a lawyer, but, in my teens, I drove a bright red manual transmission pickup truck home from vacation. It had beach stuff in the back point. Shortly after crossing the state line, blue lights appeared in my rearview mirror and I pulled over to the side of the interstate. Point officer asks me the classic, "Do you have any idea how fast you were going?" I answer the same speed as that minivan and points to the plain gray vehicle that pulled over with me a few yards in front of me, which has automatic transmission and cruise control. Officer says something like, "Are you traveling together?" I answer, "Oh yes. We're on our way home. Mom is driving the minivan. Dad is with her." Officer chuckles, tells me to sit tight, and goes up to have a chat with the minivan. Point he then tells me to drive safe, slow down, have a good afternoon, and then drives off. My cell phone rings before I take my truck out of park. Mom and Dad are dying laughing on the other end of the line. They apologized and asked what I told the officer. When I told them I was honest and pinned it all on them, they laughed even harder about me throwing them under the bus. Officer told them to slow down and stop getting their daughter in trouble, but didn't give them a ticket either. They then asked if I knew how fast we were going and the actual speed limit, since apparently they'd overlooked the last speed limit change. I knew both data points. We were over 15 miles per hour too fast, nearly 20 miles per hour over. I pointed out that the van had significantly more power and get up and go than my little 4-cylinder pickup truck, and that I had to have the pedal nearly all the way to the floor to keep up with them. They asked why I didn't call when I noticed the speed was too high, and I reminded them that their rules strictly prohibited using a cell phone while driving, especially since I was driving a stick shift, solo long distance for the first time, previously only shorter drives. I need one hand to steer and one to shift, thus have no spare hands to dial a phone number. This was all before smartphones and before GPS was on every car, so I was relying on them for navigation too. I'm not a lawyer, I'm not using the acronym, but the first time I fought a speeding ticket in court, back when you could ask for arraignment and trial on the same day, so the officer would also be there, I waited my turn. We made polite introductions, or whatever's done. Then the judge turned to the officer and said, "Please make your statement." She said, "Your Honor, on the date in question, I was patrolling I-80 in a black and white patrol car when I observed the defendant driving in the number 1 lane at 78 miles per hour, pulling out to pass a truck without signaling and accelerating. I activated my sirens, etc." As soon as she started talking, I was just about bouncing with excitement, but I waited my turn. The judge's turn too, and I immediately asked, "Your Honor, may I ask the officer a question about an inconsistency?" When he nodded yes, I turned to her and asked, "Why did you say you were in a patrol car when you riding a motorcycle?" She got a deer in the headlights look, turned to the judge, and mumbled something about switching back and forth between patrol car and motorcycle a lot, and she didn't remember which, but I followed up with a question about a car that passed me and cut me off. She didn't see it, and it was over. The judge said I'm not sure what happened that day and declared me not guilty. I walked around for 20 minutes before getting into my car and driving home, and got my money back in the mall a few weeks later, and no point on my license. My lawyer helped me and my brother win a case against our landlord. She was trying to make us pay for an exterminator company of her choosing, who was charging a ridiculous amount of money in comparison to companies we looked into. We had bed bugs through no fault of our own. A neighboring tenant/friend had gifted us his futon before moving out. For anyone interested, I'm leaving a detailed TLDR about the bed bug experience at the end of this. Anyway, after all we went through, we certainly didn't want her to dictate how much money we had to spend on an exterminator company of her choice at all. That seemed unfair considering there are other companies who are just as qualified, some with better reviews, than the company she was trying to make us pay for. The lawyer took a look at our lease agreement and noticed that nowhere in it did they state that we are liable for pest infestations. Not only that, but it basically said the opposite, and we won. We chose a really good company at an affordable price, who got the job done. We had to vacate for a while, but we were totally fine with that point. Bedbug TLDR, we were insanely unsettled by these things. I didn't even know bedbugs were a real thing. They are, and they're creepier than finding the boogeyman under your bed. They detect where we are by trailing the carbon dioxide we exhale. They gorge on our blood as we sleep, then hide, very, very well, somewhere near us, where they multiply, and multiply, and multiply 9/10 times. The only way to determine if you have an infestation is if you A. find one, or B. notice a particular rash and either go to the doctor, or try googling it. Or you're a trained military assassin, I don't know. We found one and Google told us exactly what we were dealing with. Once we knew what the little black bug actually was, we started looking in common areas they hide. Creases in the bed, pillowcases, inside furniture, etc. What we found was a horrifying infestation. So yeah. After all we went through, we definitely didn't want a landlord dictating how much we had to spend on which company. Defendant here, where I lived at the time, there were very strict statutes involving police having their body cameras on whenever making an arrest due to issues with police brutality, etc. Now, I was getting pulled over and subsequently arrested for a DWI, when the reality of the situation was that I was working in the food service industry at the time, coming off of an 18-hour shift, preceded by a 12-hour the day before. I hadn't slept, and was tired enough that I shouldn't have been driving, but I was. My wife had picked me up from work earlier, she had a long commute, and I was able to take the bus to work. She would usually pick me up afterwards, and I had gone out afterwards to pick up some beers for my day off. The following day, needless to say, failed to follow traffic rules properly. No one was injured, and no accident occurred, but it was just my luck that there was a local PD officer who had seen some swerving and me not coming to a complete stop at a stop sign. Field breathalyzer was negative, but then miraculously the one at the station showed me at somewhere between 0.4 and 0.05, with the legal limit being what it was at the time, was sufficient to get me charged with the DWI, as I also take prescription medication for epilepsy. Naturally, didn't want anything on my otherwise flawless driving record, so I lawyered up the following day. Fast forward to my first hearing. Officer at the scene gives his account. My lawyer questions him. Then the actual arresting officer came by with a cruiser. Officer who pulled me over was a motorcycle cop. Doesn't show up for the hearing, evidently having a scheduling conflict. Judge assigns a new date for my lawyer to be able to question the arresting officer. This postponement due to the officer being unavailable happens 3 more times, which is when my lawyer begins to get super suspicious. He knows something is up. After some digging, my lawyer found out that the local PD had been falsifying their station breathalyzer calibrations, and the machine hadn't been properly calibrated since they received the new machine. The officer who had started the ball rolling on ducking the calibration requirements, you guessed it, the arresting officer on my case. As it turned out, the reason he was unavailable was because he had been placed on administrative leave for the duration of the time it was taking the department to somehow mitigate the damage that would be caused by 4 years of having an improperly calibrated breathalyzer machine at their station. My lawyer was responsible for getting a bunch of convictions and charges dropped, including mine. And yet, local conservative media didn't pick up the story, and so it only made it as far as the people who lived in town who heard about it. Thanks again, Bill. You were a kick-ass lawyer. Not me, but my dad. Back in August of 2010, my aunt, who lives in Florida, had her second stroke and was in a vegetative state. So me, my mom, my dad, and my brother all packed up to go down there and get everything figured out. My mom had power of attorney. It was about an 8-hour drive for us, so we ended up just driving instead of getting plane tickets. When we were near the Georgia-Florida border, we were involved in a really bad accident that ended up with the other car in the air doing barrel rolls. We never hit the other car, they just tried to pass on the right as my dad was changing lanes, and they swerved into the grass, and eventually into the air when this happened. We were in my mom's car, 2006 Chrysler Pacifica, piece of shit car. My dad had another car, that was in his name, a 2003 Ford F-150. The other person involved in the accident was South Korean. Can't remember if she was a diplomat or a student, but she was home in Korea for the court date. The lawyer representing her went on and on asking my dad questions about his truck, without realizing that wasn't the vehicle my dad was driving at the time. Whenever the lawyer finished, my dad just asked him, "When are we going to talk about the car I was driving at the time of the accident?" The judge, confused, asked my dad what he meant. My dad explained the situation to the judge and the lawyer immediately tried to do damage control, but it didn't really matter. Not sure what the exact decision was. Dad never told me the details because I was still a kid, but our insurance ended up paying very little, if anything at all. Not a lawyer, but come from a family of them, mother and sister. Had an officer pull me over for a bogus charge, marked lane violation, when I swerved slightly to avoid a massive pothole and nobody was coming in the opposite direction. He told me he saw me overtake the car in front of me despite a double yellow. What? I kept insisting that that didn't happen and told him to look back 100 yards at the huge pothole, but he kept insisting I did, and he saw it. He wanted me to admit it and I wouldn't. I asked him to call his senior to the scene and he refuses. Guy was giving off a bad vibe, and I didn't want to get faked up by a cop, so I signed for the ticket and filled for an appeal and went to the station to file a formal complaint. Saw that there was a bank and a plaza with storefronts near where I swerved, so I went in and explained the situation and asked if they had any street-facing cameras. Luckily the bank did, and were kind enough to allow me to capture the footage on my phone, and said they'd corroborate my story if I needed it. Went to court, and let the piece of shit officer explain his side. I kept insisting that I didn't, and he made up his BS story about how I did this, and that, and he saw me. I'll let him dig his grave, knowing that already had this in the bag. Then, after there was no way he could walk back his story, I asked to show my video. Showed it to them, and had a corroborated statement from the bank manager. Also mentioned I filed a formal complaint and the officers at the station didn't seem to take me seriously. Magistrate threw out the case and gave the officer a faking tongue lashing while I struggled to hide a huge grin. Told me she'd personally look into the formal complaint and ensure the department took it seriously. I represented myself in civil court against my ex and my kid's mom a few months ago. In February the first CPO expired after 3 years separated. I have literally lost everything since leaving this woman, and she's preached that I beat her 4 years and I got shafted in court before. Fast forward to June, 4 months after her first CPO expires. Anyway, we had a small argument in her yard while I was picking my son up. A few days later I get served at my house with a temporary order. She had called the law on me and alleged that I was going to hurt her and was aggressive. Anyway, in court her and her lawyer asked me all kinds of questions about me and how terrible of a person I am, like better baby mamas do. At my turn to cross-examine, I asked simply, Miss asterisk asterisk asterisk, is it true or is not true that after the alleged argument where you felt the need to call the police and request a protection order in civil court, that our child, my kid's name, went home with me immediately after and stayed the night? Of course she answered yes, and then I asked her if it was true that the incident took place roughly around 11 AM that morning. Yes. Then why is the police report issued at 5:30 PM? Crickets. Well, I had to run to Walmart and get groceries. No further questions, Your Honor. She got absolutely dismantled by the magistrate and the case was dismissed. So this is probably far and away the most complex legal case I ever handled, and even case law was sparse on several issues. For the sake of brevity and layman understanding, I'm going to cut out a lot of details, simplify facts, and try to avoid technical crap. Point: client was seriously injured at work, like permanent disability injured. Alleged that either this was a workers' comp thing or alternatively due to an OSHA violation by the employer. Defense had some pretty legitimate arguments that my client was more of a contractor than an employee, which in this case would have killed both of my claims, among other defenses that honestly were mostly pretty good. It was a really close case. Point: basically, if my client was an employee and the employer had enough employees to need workers' comp, my client would get work comp. If there weren't enough employees, we were actually entitled to substantially more by proving the OSHA violation. If my guy was a contractor, we got nothing. Point: so a motion was filed, and we had a hearing on this preliminary issue of whether or not my client was an employee for work comp purposes. WC and OSHA kind of have different definitions of employee, or at least did at the time. The judge decided that my client was not an employee for WC purposes. But he also didn't decide that my client was a contractor either. He was a casual employee under WC law, and was therefore not entitled to WC benefits. That's bad for me and my client, right? WC would have been an easy win. It's basically handed to you if you're an injured employee. That's what opposing counsel thought. But it just so happens that a casual employee under WC law is just a regular old employee by OSHA law, meaning that the defendant owed a duty of care to my client. And it just so happens that maybe 20 years before, my own father handled a case that basically created case law in my state to the effect that OSHA regulations establish a duty of care between the employer and employee, and that an injury caused by an OSHA violation is, very generally speaking, the employer's fault. Point: so the judge basically, if unwittingly, decided at that hearing that my client was not entitled to nothing, was not limited to just work comp benefits, but was entitled to literally millions of dollars on a negligence claim. I had some fun at a previous workplace. A guy rang my desk at head office and screamed down the phone that he'd been ripped off. The call was that quick I didn't have time to take any details, and he hung up on me. Point: this wasn't my area. I dealt with online sales, not in store, so I rang around our stores to see if there had been an issue and would report it to my manager to deal with. I find the store with the problem. Guy goes to till with an item, and it scans at a different price to that on the sticker. The till operator stood firm on the price and the guy storms out. Point: as I'm writing this down, the phone rings again. It's a woman claiming to be acting as a lawyer for the guy, and she's very arrogant and egotistical down the phone with me. Point: after she finishes her long and winding introduction of who she is and all the things she's going to do with me, we start some dialogue. I ask her name, no answer. Her law practice, no answer. Her practicing ID number, no answer. So I do the same back to her. When she questions me, I can't answer that without my own legal representation. Point: eventually we hang up, and the phone rings again instantly. It's the store manager, and they have the guy on CCTV taking a sticker off another product and putting it on the one he tried to buy to get a hefty discount. I ring her back straight away and tell her the good news. Oh, I'll tell my client, faking zing. I'm sorry, you're representing your husband. No answer. Dare I inquire that you're really a practitioner of the law? No answer. You do know that in the UK, it's against the law to misrepresent as an officer of the law, as a barrister, solicitor etc. No answer. And that these calls are recorded. Click. 3 occasions this occurs when disclosure throws up the smoking gun that they otherwise said they didn't have. Cross-examination: when you have managed to tie a witness up in their own lies and you reach that point where you just know they have destroyed their credibility and the judge is just waiting to bin the case. When you get the tape/CCTV footage. Point: these have all happened a few times, but the best was in cross when the witness is referred to the diary note he kept. We had been seeking unredacted diary entries prior to hearing. We called for the diary in cross and his lawyers bloody had it with them. We called for an adjournment to review, and the judge only gave us 30 minutes. We went into the counsel room and started ripping through the diary, hitting key dates in his evidence. Now this guy diarizes everything. Dog walking, naps, washing his car. Basically recorded everything he did during the day and how long it took. God knows why. It was weird. Point anyway, each key date had a detailed record of the key event which had been surgically redacted when the page was exhibited to his affidavit. In each case the diary entry contradicted his evidence and proved my client's evidence. Point now this witness was now sheeting himself. He knew the gig was up and he was looking at perjury once we exposed him to the judge. When we returned he looked visibly unwell. Point we could have gone straight to the diary. We didn't. We continued with our cross, slowly watching this guy decompensate for about an hour as his anxiety skyrocketed. Then we pulled the diary out. Point after going through about 3 events, asking him to read the paragraph in his affidavit, then making him read the record from his diary, the judge called a halt and asked the witness to leave the room. By this stage he had been digging his fingers into his palms so hard he had opened them up and blood was running down his palm. Point the judge basically said she was going to refer him to the DPP, Australian State Criminal Prosecutors, but gave his lawyers an opportunity to resolve the case before calling the witness back in. Point unsurprisingly they offered to pay my client's costs in full and the full amount plus more of what we were claiming. Point the witness is left a ruined man. I currently work in law and have for a few years now. What kick-started my interest was when I had a crazy ex-girlfriend out our false charges on me after I caught her cheating. We worked together. I caught her when I went on lunch and looked through her phone that I bought for her. She had an entirely separate SIM card in it and was using it to text people without me knowing. I found hard proof of her cheating and took pictures with my phone. I took the phone, told her I always knew she was a cheating hoe, and left work for the day. It happened in front of everyone. Later that night, she begged me to meet her to get her phone back for her baby pictures. I hear there but I'm suspicious. I get there, and there's cops waiting for me. I leave, and I guess they knew my vehicle, because I was pulled over nearly instantly. Full on ran at my car, and told me to keep my hands up. They force me to give the phone back. I tell them I've got nothing else of hers, but she has stuff of mine. They tell me to let it go, and I agree then leave. We had no contact after despite her best efforts. A week later police are beating on my door with an arrest warrant. My brother is a cop luckily, and the person sent to the door knew me. He let my brother do the arrest. I was very confused, and then I read the charges and my brother got me all the reports. She tried to say I was threatening her and acting like I was going to beat her. There were a few pages of texts I had no memory of sending at all. Charges with assault and harassment, one of which is a felony where I'm at. I got out on sig bond and got a public defender. A no contact order and order of protection is placed against me. If I do much as tell her to leave me alone, I'm in jail. He told me point blank that I need to plea out cause there's no defense here. I tell him that it's all fake and I can prove it. I call my workplace. I'm fired. She told them I hit her. I ask them to check the cameras and they tell me no. I inform my attorney and he says he'll get footage subpoenaed. That never happened. So the next 4 months I'm doing all the discovery for him. I found out she used a text app to text herself as me. I found inconsistencies in her own police report. I found where she tried to break into my accounts on damn near everything. I had coworkers write affidavits that I didn't hit her or even try to. I took it to him and he gave me to a different attorney. She said the same thing and added that our particular judge won't understand that she used a fake number despite her herself believing that. I sigh and get ready to take some months in jail. Then, the literal weekend before our trial, she texts me on my new number, no clue how she got it, and literally blackmails me into trying to testify against her ex-husband for full custody. Says she'll drop the charges if I do. That's not how it works though. I ignore her and print all the texts and take them to my lawyer, who shares it with the prosecutor, who takes it to the ex, and she acts dumbfounded. The attorneys approach the judge and speak off mic. The judge then puts the case under advisement for a year, meaning the case is dismissed if no issues come up between now and then. She doesn't even get a slap on the wrist for the false report and attempted extortion. Nothing at all. For the next year and a half my now wife and I live in constant fear of running into her, and she makes 2 attempts to contact me. Both times, the police ignore it. Eventually the 1-year mark hits and the case is dismissed, but if she would have just shut her mouth, I'd have been in jail for a crime I didn't commit, and she would have won. But she completely faked herself by trying to blackmail me. Drex tried to say I beat her, and it goes to court with me looking at jail time. She attempts to blackmail me the weekend before the trial, and gets the whole case dismissed. Our fake judicial system lets her off completely free despite the false report and attempted extortion. Not a lawyer, but I used to play one on TV. I had a moment like that when myself and 3 of my friends defended ourselves against loitering tickets for stopping in the parking lot of a strip mall. This is in small town America, where Barney Fife and crew get off on harassing teenagers just hanging out and talking. People would cruise the main street and then make their turn around at the local Taco Bell in the strip mall. Local police would stake that area out and harass one car after another full of teenagers. Eventually they put signs up on the light poles saying no loitering and listing hours you could not be in the parking lot. Well, some genius mounted these signs near the top of the light poles so they could be read by the light of the street light. One weekend we were in my friend's car making the required drive-through turnaround when a car full of girls pulled up beside us. We started our pickup routine and were rudely interrupted by 3 cop cars flashing their red and blues. Of course they made us get out and search the car, probably illegally, and not to be outdone, when they found nothing, they wrote all of us tickets for loitering. In court we got the cops to admit we were in our cars with engines running. Idiot cop said I told them to turn their engines off and pulled up to driver side window talking through the rolled down window. My friends were trying to argue that we weren't parked because engines were running or out of our vehicles, but that was not convincing the judge. Finally I had an idea. Only reason I got this idea is because I just retook my license test and remembered the questions. Me. So if we were parked that is considered loitering, even if the car is running? Judge. Yes, me. So essentially if you drive into that parking lot to just turn around without stopping you are not loitering, correct? Judge. Correct, me. Only if you stop or get out of your car. Judge. Yes, me. So essentially the no loitering signs are there to tell people driving into that park lot that they need to continue passing through and exit the parking lot without stopping. So if these no loitering signs are designed to be read by someone in a moving vehicle, why are they mounted at the top of the light poles, at least 12 to 15 feet in the air? Judge. Officer, is he correct about the mounting height of those signs? Officer. Well, yes. But if we hung them at traffic height the kids loitering there would have defaced them. Me. Anyway, blowing off the defacing comment, how are we supposed to see those signs when we are driving our cars, eyes on the road, not looking 15 feet in air at top of a light pole? Even if just sitting in our cars, we would have to exit the vehicle to be able to read the signs, at which point we have now broken the law. Judge, you have a point there. My hold it moment. If those signs are directed at moving vehicles and designed to instruct people in moving vehicles they cannot stop, then they need to be mounted at the required height for a traffic sign. I'm dismissing the charges against the defendants and advising the Earl of Police Dep to move those signs down to regulation traffic sign height as soon as possible. Also, boys, we both know you were loitering in that lot, so you're getting off easy, but you made a good point. Do me a favor and stay out of my court as defendants, please. All 3 of us. Yes, sir. The cops looked so pissed. They had successfully ticketed a bunch of people for that loitering bullshit over the weekend, and there were cases with the exact charges waiting behind us. This happened in summer of 1990. First case I successfully defended myself in, but jot my last. My greatest legal win. I did pro bono work for a friend of mine. Domestic abuse, filing for a plenary order of protection. I was really hesitant to do it and only did it because other friends begged me to. Went over everything and was ready to go. Show up to court. I exchange exhibits with the guy and there are tons of emails sent by my client begging to see him, and one email literally saying, "I jaff that the judge says there should be no contact. I want to see you now." I'm sweating and mad this lady lied to me. I did my direct, and on cross he is really digging in. I begin to flip through his exhibits and notice something. I smile the biggest weirdest smile ever. Even the judge notices. Then I put on the show. Isn't it true you swore to tell the truth? Answer, yes. It's your testimony today that these emails came from my client. Answer, yes. At this point the judge knows him up to something. She tells him that if I can prove that any part of his evidence is not the truth he will be held in contempt. The guy continues his story and affirms it is. Then I ask the judge to read the little URL code at the bottom of the emails we knew to be real because also included in my evidence package. I begin to explain that this URL code appears on any page you print, that each piece identifies different info, etc. Then I had the judge read the URL code of the emails I said to be felonious and perjurious in nature. There was an audible gasp in the courtroom. Dude went into drafts and made a bunch of emails to contradict my client, then printed them out to make them look real. The judge asks again if he lied and made these. He admitted he did. The judge grants my motion, denies his motion, holds him in contempt, and the bailiff carts him off to jail. I'm not a lawyer, but I did go to court to contest a speeding ticket point. The cop had pulled me over one night while driving back from the Grand Canyon, moments after a red Ford Ranger had gone speeding by me. I asked the cop if maybe he made a mistake and pulled over the wrong car. He told me that he doesn't make mistakes like that. He gave me a $350 ticket point later. After taking a closer look at the ticket and seeing 2 mistakes on it, I decided to contest the ticket in court. The courthouse was 2+ hours away, but I felt I needed to stand up for myself. Court day came, and the cop showed up. When the case was called, the cop proceeded to read from his notes. Blah, blah, blah. While traveling north on I-17 in a red Ford Integra. Then came my turn. I told of seeing the red Ford Ranger speed past me that night, just before being pulled over by the officer. I then provided 2 pieces of evidence, my car registration showing I drove an Acura Integra, and a receipt from the Grand Canyon, indicating that I had to have been driving south on the freeway that night. The judge asked the cop, what do you remember happening that night? The cop started reading his notes again. The judge interrupted, I didn't ask you what your notes say. I asked what you remember. The cop started to explain why he needed his notes, but the judge interjected. Your notes are crap. If you don't remember what happened that night, you don't have a case. The cop started arguing again, and the judge just smiled and shook his head. I've heard enough. Case dismissed. I walked out of that courtroom feeling like I just made Jack Nicholson admit he ordered to the code red. Always check your speeding ticket for mistakes. Not a lawyer, but we lived in a flat in the UK that we found through a letting agency who charged mad fees for all sorts of things, but our landlord was incredible. He left us a bottle of wine for our first night. He always gave ample notice when he needed to come over, and even sent us a Christmas card. Over the course of the year we had a few wear and tear issues that we raised with him directly, like beading coming away from the skirting board and the door that came with the garage starting to stick. He also gave us written permission to paint our bedroom, as long as it was a tasteful color he could agree on. All of this was done over email, because he was always too busy with work to speak directly. In the last week of our tenancy he scrubbed the place from floor to ceiling, so it was spotless for the next tenants, which we think is only fair, because it was clean when he moved in. The landlord also let us know that he might be there when we moved out because he had a conference on the day after we moved and he wanted to stay at the flat rather than get a hotel, as well as say goodbye. As we were doing the last load of washing, the washing machine broke and flooded, so we let him know immediately and he said it was unlucky but fine. Several weeks later I contacted the letting agency about getting our deposit back, which was something like £800. They replied to let me know they were calculating the deductions based on the professional deep clean that had to be done, the repairs to the beading around the skirting board, the cost of redecorating the bedroom, and repairing or replacing the washing machine. Needless to say we were furious as all of this had been pointed out to the landlord, but there was nothing they could do. A few days later they told us it was unlikely we would get any of our deposit back. Cue me looking at our tenancy contract. Our contract plainly stated that any deductions from the deposit must be agreed between the landlord and the tenant. I called our landlord to discuss, and he said he didn't agree to the deductions as he understood the wear and tear issues. Let us paint and the washing machine had already been replaced at his cost. He then emailed me to confirm this. I forwarded his email to the letting agency with 2 sentences from myself. Please find attached an email thread confirming that landlord and tenant did not agree to any deductions. As a third party, you have no legal right to make said deductions from our deposit and would appreciate immediate payment. The letting agency called me 10 minutes later saying that they are already paid for all the work. I told them tough shit. Money was in our bank the next day. Always read your contracts, folks. But I was the victim. Years ago I was riding my motorcycle to work, and this idiot skips a red arrow to immediately freeze in the middle of street when he sees me coming. It's an avenue and his car was taking most of the 3 lanes, and he was looking at me with a dumb face instead of taking his car out of the way. With no options left, I try to slow down without losing control, and at the end just jump from a moving motorbike above and SUV. Never done anything close to it in my life. I smashed against the car and broke some bones. The helmet saved my life. My lawyer comes to see me after the operations and tells me there is a witness stating I crossed a red light and the SUV was doing nothing illegal. There's even a sketch of the situation. Turns out the witness was a municipal inspector, and at this point I'm starting to have second thoughts. Maybe it was me, but I knew that avenue by heart. I knew if I catch the first green light then it's all green and smooth until the first roundabout. The avenue is loaded with cameras, since it used to be an illegal racing track occasionally. So we are waiting for the recording. My lawyer checks himself about the green lights and decides to dig up about the inspector. He finds the inspector was not where and when the accident happened, but was actually in the patrol car that responded to the call. This was pointed out by the policeman in that patrol car himself. And the recording from the cameras is blank from exactly 5 seconds before the accident, and for exactly 30 seconds. I don't know the proper term in English, but the judge called for this inspector to provide his testimony. He was called 3 different times, but never showed up, so the 4th is by the police. Police presented themselves to the judge and informed that the inspector committed suicide days ago. He was facing years in prison after selling his testimony to multiple situations just like mine. And in the recording left, it was visible when he was drawing the sketch in the hood of the patrol and receiving some cash afterwards. The case is not yet closed, but his testimony was dismissed and the dumb fuck admitted crossing a red arrow. And from then on I like to say that the only witness against me surprisingly committed suicide. Not a lawyer, but this was one of those courtroom drama cases. On my way to my first day at work for a part-time job between high school and college, I saw an accident caused by a person running a red light. I was approaching the intersection and took note of the light changing because I was running a few minutes late. Then I see the first car to go get hit from the left side. Big crash. Both cars slammed into the curb. The guy who ran the light, a tall, skinny guy, jumped out of the car and ran. I was going to be late now, but I had an excuse. I gave a statement to the police, drew a diagram, etc. A few weeks later, and a Phoenix police car pulls up in front of my Tempe home, and a police officer hands me a summons to appear in court. When I got there, one of the prosecution attorneys met me and explained that the case was going to trial because the guy who got hit was seriously injured and the driver left the scene. As a witness, I waited in the hallway until they called my name. There was a recess and then I was called. I was sworn in and the prosecutor asked me to describe what I saw. So I did. The direction of travel, the color of the light, the impact, the guy who ran the light jumping out of the car and running away. Then it was the defense attorney's turn. He questioned how I was so sure about the light color and about the guy running away. And then he motioned toward the defense table and said, "And can you point out the person you saw running away?" I looked. Tall skinny guy, but not quite the same. So I told the truth and said no. His face fell. He asked again, pointing at the guy sitting next to his associate. I said no, that's not him. I was dismissed, but subject to recall, so I went out in the hall again. The prosecutor followed me and told me that I had just won the case for them. At the recess, the defendant and his brother changed places. The defense wanted me to misidentify the guy as a way to cast doubt as to my testimony. The state did win, and they sent me a letter letting me know and thanking me. I thought it was a pretty cheap move, but it didn't work. Years later, in college on the GI Bill after the Navy, a classmate told me she was preparing to take the LSAT and asked if I wanted to take it too, so we could be study partners. I kick myself sometimes for not taking it and going on to law school, but I wasn't the best student then and said no. 14 years later, I went to grad school at a top 20 private university and had a great GPA. Not a lawyer. A bit of backstory. First point, long story short, my ex-husband was an abusive pose and typical narcissist. Verbally to me, never hit me or my daughter. We separated. He got a place living on the second floor of a home with an enclosed balcony. You could push the windows open, they were so old. Anyway, my 5-year-old at the time threw a bunch of stuff out while he was asleep. He woke up, beat her, then texted me about it. Things like, I really faked up. She won't stop crying because I spanked her, and later after he calmed down, I think she has pink eye. I told him just to cuddle her and tell her it's okay, etc. I picked her up the next day and her face was black and blue. She had handprint bruises all over her back and legs. Oh, and she didn't have pink eye. He beat her so bad that the capillaries in her eye ruptured. Picked her up the next day. Now, he had this thing where he would lock me in his house if I disagreed with him, so I told him we would see him tomorrow and left. Took her to the hospital. Filed a restraining order. Went to a lawyer the next day. I told my lawyer what happened, brought my phone, and showed her the texts and more. After about an hour of telling her what had been going on during our divorce and finalizing with my daughter's case, she looked at me and said, well, I don't know if I want to take the case. This happens all the time here, and the best I could do is get you a divorce and split custody. I looked at her, showed her a picture of my daughter and said, she's 5 years old, nonverbal, and has Down syndrome. She looked back at me with wide eyes and said, when do you go to court for the restraining order? I'm going to fit you in my caseload. P.S. We won. I got sole custody, didn't ask him to pay child support. We gave him a year to redeem himself, and in the long run, he didn't do one thing that was listed on the court docket. I'm an auditor. We were auditing a medium-sized bank who seemed to have given out a massive amount of loans, and I mean massive, like 30% of total assets, to the companies that all seemed to be interconnected and kinda weird. This was without any economic justification, and was not clear what these entities are doing and how they were going to repay the loans. I interviewed head of risk, the guy who was supposed to be on top of this sheet, and was overall asking about controls and processes in place, and how they make decision on giving out a loan, how they then monitor credit quality, etc. And then mention that for these massive loans we were actually not able to get much of evidence in terms of their oversight. To what he says, well, we don't need to monitor them. These are all our companies. He then immediately tried to take it back, saying that these are old clients they have had for years. Quick online search, and yep, most of these entities registered to family members of the directors and management. They were effectively stealing from the bank for ages, taking out these loans and knowing they will never return them. I know we would have got there, even if the guy didn't say it, but would have taken us longer. I also think the guy was so careless, because I was very junior at that time, literally a 23-year-old shy non-threatening blonde on my 3rd year of audit, was never going to lead that interview, but the senior manager who was supposed to be there couldn't make it. He didn't think I was a threat. Well, suck it. Hope prison is going well. Now a lawyer, but my husband went to family court with baby mama. She managed to schedule a court date and get custody time taken away from my husband by sending the court hearing notice to his old residence. He wasn't aware of the hearing, so he didn't show up, and baby mama got to reduce his time spent with stepkid. Fortunately, my husband had scheduled a court day around the same time baby mama had filed for her sneaky one, so they ended back in court a few days after the fuss hearing. The judge asked why they were back so soon after my husband missed the last court date. He explained that baby mama sent the hearing notice to the wrong address, knowing he had moved. Baby mama lied and said she didn't know he moved, but in reality, that lying piece of human garbage not only knew we had moved, but had picked up stepkid at our new place. I watched her lie straight to the judge under oath and my mouth legit fell open. Judge held recess right after that, and my husband and I got to work scouring all the old text message documents between me and baby mama we printed out for the hearing. We found the text where he told baby mama his new address months prior to the court hearing and had a hold it moment. Showed it to the judge after recess and was expecting the judge to send her as to jail for contempt of court, but baby mama doubled down on her lie claiming she didn't see the text. Judge said she highly doubted that and moved on. Point: there is no justice in this world, especially for single dads. It sucks. I had a utility client have a buried line get broken after a construction company literally blew up a mountainside and the debris came crashing down on my client's buried cable. The construction company never called to locate the utilities before blasting. Big no-no. The project was supposed to blast a little, clear it away, then blast some more, but apparently it wasn't going fast enough, so they just decided to blow it all up in one go. After about 6 months of trying to get the company to just pay for the repair and replacement costs to my client, we got serious and filed suit. I sent multiple rounds of discovery trying to get a copy of a video that several employees of my client in that small town reported having seen. The construction company's attorney always answered that no such video, record of any type related to any blasting in that area existed. Straight up denials, multiple times for months and months. They also kept claiming that they didn't perform the blasting that caused the mountain to collapse, nor could they have, because they didn't have the proper licensing to conduct blasting. Point: a year later, we are now about 2 months away from trial, and we pitched one last offer to try to get them to settle, and they agreed to mediation. 2 weeks before the mediation I do my routine check of the construction company's Facebook page. Lo and behold, what is this? There's a new video that was uploaded a few days before by the construction company entitled, "Sometimes explosives are the answer." 2 minutes and 6 seconds of glory later I was dancing around my office laughing my ass off. Point: at the mediation in my opening statement I repeated my discovery requests and read their answers, stating that I just didn't believe them, they did it, blah blah. The construction company stands up and repeats the same denials and doubled down that his client didn't do the blasting and that there was no video to produce in discovery. Point: we go to our separate rooms. Mediator comes in and asks us what we want to do. I just pulled up the video on the construction company's Facebook page and press play. At the end I said, we want 100% of our repairs and replacement costs plus 100% of our attorney's fees, and that the mediator was free to share the video with the defendant, and remind them if we win at trial we will get treble damages. It was a small community and my client didn't want blood, just what was fair. The mediator was floored by the defendant's blatant lying. It took 10 minutes for us to get everything we asked for. But since we are talking car accidents, I remember being about 13 or 14 and witnessing a pretty violent accident. What made it memorable is it was some holiday, I think maybe Thanksgiving, and everybody was at my grandparents' place, like 30 people, cousins, second cousins, everybody. Well, grandma needed something. Uncle one volunteered to go run the errand. Turns out his car was in the middle of the pack, so he asked another uncle to borrow their car, who asked if he knew how to drive a stick. Uncle one is a retired fighter pilot, having left the Navy around at the end of Vietnam after serving 20 plus years. Fighters don't have automatics. I can drive a stick. Point: about 15 minutes later he stalled pulling away at a green arrow. I hear a car go flying past us on the right. A car had pulled into the lanes that go straight and gunned it into the intersection, misjudged the distance, and collided with a pickup truck in the corresponding lane coming from the other side of the intersection. Her car impacts the center of the truck bed, knocking the small pickup partially airborne, so it's only on the right side wheels. It stays shiny side up and eventually lands on all 4 tires again, but the tailgate ends up in the road. Not half a second later there is a blue flash behind us. I look up into the rear view mirror. There's a cop slowly pulling out into traffic. He had to have been almost right behind her, maybe one car separating them, two at most. So you have the victim's testimony backed up by eyewitness testimony who happens to be the first officer on scene. It was actually very recent. I'm a baby lawyer, just hit my first year licensed, and I was in court for a default hearing this past Tuesday. Opposing party didn't bother showing up to the original hearing, so the judge ordered a default hearing. I filed my default judgment on Monday, and I get a call from an older attorney, like licensed 8 years, before I was born old, explaining that he's going to file for summary judgment, because I had forgot to tick a checkbox on my certificate of service, and thus his client was improperly served and this would be my last chance to stipulate for a dismissal. I told him I'm not stipulating to cheat. I had proper service despite that mistake, and was willing to go on the record, admit my mistake, and show proof that it was properly served, and that the only fuck up was me forgetting to check a box. He cockily says that it's on me to explain to my client why I'm going to lose point. So I sit there as this man says on the record that my assertion that everything was proper was disingenuous, and I fucking lost it. When it was my turn to speak, I just hit the judge with word for word the following argument. Your Honor, opposing counsel had a beautiful rant that he wants to call an argument. He calls me disingenuous, but showed up to a default hearing without a motion to set aside the default and a summary judgment motion, and is throwing around serious accusations. Both opposing counsel and their client knew about the hearing last week, because opposing counsel emailed me asking me for the filings, because his client hadn't sent them to him on October 27th. Frankly, the most disingenuous thing is that opposing counsel didn't show up to the original hearing, shows up and tries filing and arguing for summary judgment when neither he nor his client even have a right to hear. They're in default. My client's done everything right and showed up last week, and should not be punished, because opposing counsel doesn't believe in respecting the court's time, and used it as an excuse to buy more time. I was cut off during that last sentence by the judge who asked me, counsel, is 30 days to remit payment good enough for your client? Yes, Your Honor. Thank you, Your Honor. Opposing counsel refuses to answer my emails or phone calls now, so December 10th is going to be an interesting day, lol. Not a lawyer, but my mom and uncle were sued by their deceased brother's children, my cousins, over my grandmother's will. She left her house to the 2 surviving children. She removed my deceased uncle from the will prior to his passing, because he had a drug problem his entire life with multiple trips to jail. So when he passed, the will didn't change, since he was no longer in it. My cousins tried to sue, saying they should have received their dad's portion. This process was drawn out over 2 years and multiple court dates. My grandmother was fully competent up until her passing from ovarian cancer at 91. My cousins alleged she wasn't in her right mind, and my mom/uncle coerced her. My cousin took the stand, basically said she was extremely close with her grandmother despite living 10 states away. Further said my grandmother used to tell her she would include her in the will. My grandmother never talked like that. Anyway, on cross-examination my uncle told the lawyer to ask if she could tell the court when her grandmother's birthday was. Lawyer, do you know when your grandmother's birthday is? Cousin, I can't recall. I'd have to check my notes. Lawyer, could you at least tell me what month it was? Cousin, September. Lawyer, it doesn't appear you were as close with your grandmother as you are portraying here today. Her birthday was in May. Even after all of that, judge asked my mother/uncle to show a sign of good faith and offer them something to settle the case, because he doesn't want to see any more families torn apart by money. After consideration, my mother and uncle offered them $20,000 each. They rejected the offer as the house was worth $600,000. The judge then dismissed the case, giving them nothing. And we never talked to them again. I've had to run my own defense in an unemployment claim before. I was working for a AAA developer, games, and when the project was winding down, the company let go about 60 people including myself. When it came time to file for unemployment, they denied it to all 60 people. This is an NC. They basically automatically denied it, knowing most people wouldn't fight back on it. During the private hearing, the representative claimed I was let go for using the internet, which was literally a part of my job. When I asked about the other 59 people, she claimed ignorance, and the whole thing was covered by Kotaku. I pulled up the article on my phone and showed it to the arbiter. The arbiter asked the representative if they had anything further, and they said no. The arbiter then asked me if I had anything to say in my defense, and all I said was, is there any physical evidence of the claim being made against me? The arbiter looked at the representative and said, do you? The rep said I was not given anything by my client. The arbiter immediately ruled in my favor, and I received my unemployment in full. I'll never forget that feeling, and I will never buy anything from that dev ever because of that, and how they continue to abuse their employees to this day. I was trying a shoplifting case as defense counsel. I was convinced they couldn't make the case. In my opening statement, I apologized to the jury that they would not get to render a verdict, because once the state had finished its case in chief, I would ask the judge for a directed verdict, and he would grant it. They put on Walmart security, and the rookie prosecutor forgot to ask him whether the person he saw in his testimony was in the courtroom. After cross-examination, the judge did not ask the lawyers whether the witness was excused, which is unusual. I knew why he did not, and so did he, but the rookie prosecutor did not know that this was strange at all, and it would have been illegal for the judge to tell her. I said something like, Judge, I know you're new to the bench, but I think it would be common practice to ask whether the witness is excused. The judge knew exactly what I was doing, but it's against the law for judges to give legal advice or make comments, so he just asked the prosecutor whether the witness was excused, and she said yes. I said he was excused from the defense as well. After she had finished with a second witness and closed her case, I turned to my client, who was quite nervous, and said, this is about to be over. I stood up and moved for a directed verdict because there was no witness that even put my client inside the store. Sure, there was a description of the conduct of a female, but the witness never said that the female was my client. Because the witness had been excused, the prosecutor could not call store security back to the stand to fix this problem. The judge granted my motion for directed verdict, and afterwards patted me on the back saying I had made a nice move, and then ordered my bill paid in full. About an hour after my client had left the courthouse, I got a call on my phone from a lady at the local newspaper. She said that my client had come to see her and wanted to take out an ad in the paper saying that I was the best lawyer she had ever seen. The lady from the newspaper wanted to know if that was okay with me. I said that I had not asked for it, but that my former client has a First Amendment right and can say what she likes. Moral of the story: when the enemy is destroying herself, do not intervene. Not a lawyer, but my personal story. 6 years ago I was pulled over for an illegal turn, and the police weakened their way into making me wait over 30 minutes for a canine to search my car. I stood my ground and refused consent because it was clear there was no legitimate reason for this. However, when it comes down to it, there is not much you can do when the police have their mind made up. I was charged with 3 felonies for possession/distribution of illegal substance. I did my research and found out they faked up by making me wait for the dog. They cannot extend the time of a routine traffic stop without probable cause. A year or two later I went to court to fight it. The lawyers went inside, and it was just the cop who arrested me and myself outside. I walked over to him, shook his hand, and said, as a result of everything that happened in our interaction, I have completely changed my life. Thank you for everything because I would not be the person I'm now without you. He looked dumbfounded and said, it is great to hear that, because you were obviously going down the wrong path, and I got into this work to help people. The lawyers came to get us, and the hearing began. The cop took the stand, and it was a real roller coaster, as the prosecutor asked questions, and I was like, oh geez, I'm faked. When my lawyer asked questions, I was feeling pretty good. Back and forth. At the end, my lawyer asked, so you did not have a legitimate reason to search his car? So, not a lawyer, but did my own defense. When my health insurer sued me for not making payments in the Netherlands, we have private insurance. I moved abroad for a year to Denmark, where health insurance is state-sponsored, at least, basic package. So I cancelled my health insurance in the Netherlands, told them I moved abroad. Upon returning a year later, I called my insurer telling them I want to be a client again, and they're like, but sir, you're already our client. And you haven't paid for a year. A few days later I got the court notice for them suing me. When the case came before the judge, I collected my evidence of me cancelling, and they sending me confirmation messages etc. They had to send in their evidence to me as well prior to the case. Basically, in their package of evidence was a physical letter they sent. All other communication was through email, to my old address. I told them I moved in there. Form. So why do this? The letter said something along the lines of, we re-enabled your health insurance because we thought something went wrong and you can't be uninsured. If you don't reply to this letter, we'll cancel it automatically in 30 days. So, when it was time for me to make my case, I basically introduced all my own evidence and then took that letter from their package and said, Judge, why would someone send a letter to a place you know the addressee doesn't live anymore and expect it to be read? And, why would you state, in that letter, that you'll cancel the health insurance if you don't get a reply, and then not do it, only to sue me a year later? What if I had received that letter and decided to do nothing because I wanted to be uninsured? Judge reprimanded them for sending that letter because they weren't allowed to actually cancel insurance if they suspected I had no alternative. They had to change information on their website as well, and had to compensate me for taking time off work to prepare my own case. The rate was higher than what I made, plus my boss wasn't too strict on enforcing fixed paid time leave, so I actually made some money off this case. Feel like I'm getting in late on this one, but here goes. Not a lawyer, by the way. When I was 17 I rented an apartment in cash from a slumlord. Maybe 2 years later I decided to move out etc. I had the landlord sign an N12 agreement and all stating I could leave. I helped him have the place ready for showings countless times in the 2 months leading to my leaving. The last day I'm going to meet him to give him the keys, I was just upstairs cleaning and he knocks on the door. I open it to him showing a folder in my face and demanding the key. So I said, you'll have to wait a few hours, this is still my place today. Turns out the paperwork was a small claim suit for $5,800. He was trying to claim everything missing, apparently 3 months rent, $300 cleaning costs, his wife cleans the apartments, to saying I damaged the baseboards and all. So I went to my old apartment the next month and met the couple who was renting it. When we showed up at court I was maybe 19 to 20, and I imagine he assumed I wouldn't defend myself and he would get a free ruling. The judge heard his piece and quick he told him this doesn't even belong in her courtroom, it belongs in the landlord and tenant board. Then the landlord goes on to talk about lost rent. When he was finally finished I asked the judge if we could go back to the lost rent, then asked if it was currently rented. Cue anger from the judges, you cannot rent the same apartment to 2 people at the same time. The judge told me to call a paralegal. When I did that, the paralegal was like, oh no problem, this case is over, he can't sue you when you still had the keys. So we wrote up a document or whatever and the case was dismissed. Most of mine are fairly boring. Witness unexpectedly told the truth, admitted they had lied previously, etc. However, one of my favorites was told to me by the loser, a county prosecutor who I regularly litigate against. He is prosecuting a middle-aged woman for a DUI. She managed to bury her sedan some 20-30 feet into a snow-covered farm field. Somebody calls it in. Cops find her passed out, soaking wet, and smelling like she tried to drown herself with the 2 empty wine bottles they found in the backseat. Her version of events was that she hit some black ice causing a fairly high speed slide off. She had a full tank of gas, and although she only lived a mile and a half up the road, she knew her husband wouldn't be off work for another 3 hours. So, she says she decided to leave him a VM with instructions to come pull her out, and proceeded to have herself a good time. Although I have to believe the prosecutor knew roughly what story she'd tell, some specifics must have surprised him, because he ended up asking the investigating officers some blind questions on recall. Although sometimes you have to, it's generally a no-no to ask a question you don't know the answer to. Looking closely at the decent crime scene photos, he realized there really weren't many tracks disturbing the perimeter of the vehicle at all. The exchange went something like this. Well, officer, if she drank all that wine while she sat there, I imagine she'd have to relieve herself. The officer began to laugh, which the prosecutor took as encouragement. P. Well, I don't see any tracks outside the vehicle. Oh, no sir, not really. More chuckles. P. Any yellow snow? Oh, no sir, not that I recall. P. So evidently she just has a very large bladder. Oh, well, actually. The prosecutor was looking at the jury to see how his astute observation to land when it suddenly dawned on him a moment too late that soaking wet was a polite euphemism. The defendant went an appropriate shade of red. A few jurors chucked along with the investigating officer, and the prosecutor knew immediately he talked the jury into an acquittal. Germany, old lady with no signs of dementia forgot a pan with bacon on the stove, which caught fire while she was in the bathroom. As a result, the whole house burned down. The insurance company refused to pay because of gross negligence. In prep I asked her how an experienced cook like her would not turn off the stove before going to the bathroom for more than a minute. She was kind of evasive and said she really needed to go because women stuff. As a young man I really didn't want to go into detail, but I insisted to elaborate and spare no detail, all of which was really uncomfortable. Turns out she had some type of medical procedure down there and had a catheter removed the same morning. She was overwhelmed with the urge to pee, had promptly peed herself, and in panic, rushed to the bathroom, where she was in severe pain, and it took some time to get better. Over all this, she had forgotten that the stove was still on. The burden of proof for gross negligence is on the insurance company, and since we could provide medical records to back our story, and it was probable to have happened that way, the insurance company fell short. Their lawyer was all but that, cried that there was no way they could unproof our story, and accused me to have made it all up. Yeah, whatever dude, Granny needs a house, get over it. And as I remember it, the story was indeed all true. I had mine at the same time as the magistrate who was hearing the case. The Home Office here in the UK was trying to bar two gay women in a relationship from gaining refugee status. If this happened, the women would be at risk of persecution and attack if they went back to their community in Nigeria. They'd already been violently attacked once. I was pretty sure we were going to win anyway, but then as part of their defense the HO referred to their own guidelines that two people who claimed to be a couple would have their case harmed if they were not cohabiting while in the UK awaiting their case to be held. They also had an instruction from their own UK Visas and Immigration Department declaring that each member of the couple had been allocated a place to live pending their cases being heard. Note allocated, that was the place they had to live. One was near Bristol and the other in Leeds. Two cities that are 200 miles apart. And asylum seekers have no access to private funds, but instead live on government stipulated amounts each week, which do not include the ability to travel to and from Bristol and Leeds. That the couple were in a relationship was both the reason for their seeking asylum and the only criterion by which their cause could be realistically contested once they arrived on British shores, which they did voluntarily. To be fair to them, everyone had already noticed it, and the Home Office people just raised one finger and basically said yes, we've seen it too, we'll just withdraw our objection now. The judge, yes that would be best, thank you, me. Packs up documents in a business-like manner, while my internal child rolls on the floor laughing. Sometimes the universe just says, there you go, there's one for free. It was a Standing Rock trial in North Dakota. There were 2 felony charges and a misdemeanor charge that got thrown out a directed verdict. I had a moment like that for each of the 2 felony charges. Charge 1, reckless endangerment. The claim was that my client had tried to run a police car off the road. The officer had dash cam of my client after what he claimed happened, but not before. I had already pinged him once because I had a copy of his dash cam that he had given the prosecutors and was given to my predecessor, but that they had since forgotten existed, and I had a transcript of the cop swearing under oath that there was no dash cam footage at all. So I had a nice shot at him for that, but the real aha moment came later. I had him on the stand, watching the video he had taken, and then denied taking. He had admitted it was the authentic dash cam, and that the voice on it was his own. He said that before the video started, he had been forced into a turning lane, and that had someone been in the turning lane, there would have been a head-on collision point. I asked, would it surprise you to learn that from the moment this road enters town until the place where this footage starts, there are no turning lanes? He said no, and looked quite embarrassed. So that's one acquittal in the bag. Charge 2, resisting arrest for a felony. It was the evening of day 2 of a 3-day trial. The jury had gone home, and the judge and prosecutor and I were arguing about the finer points of the jury charge. It was an element of the offense that the arrest resisted be made lawfully, and yet the prosecutor had not stated which law justified the arrest. Most state government codes have a list of times it's okay for police to arrest someone in addition to the federal constitutional minimum, and my prosecutor had not cited anything from this list. I said that I would not do his job for him and find the list, but that if he could not identify a specifically defined legal right of the police to arrest, then the arrest was not lawful, and he could not make a case for resisting arrest. The prosecutor just could not figure out what I was talking about. It seemed self-evident to him that police can arrest whoever they think broke the law. He couldn't figure out that this would actually be written down somewhere, and he had no clue as to where it might be written down. In the end, he just insisted that there not be a jury instruction defining when an arrest is lawful, but he had no problem with the idea that he had to prove beyond a reasonable doubt that the arrest in this case was lawful. He was insisting on setting an impossible problem for himself without knowing it, and I simply stepped out of his way and let him do it. As my client and I walked out to go get some sleep, I told him we had just won the case. In closing statements the next day, I explained that we had given them what's called a closed universe problem, meaning that all the law in the whole world was written down in their jury instructions, and that they were not allowed to use any law, but that to make their decision, even if they knew other law, they were not supposed to think about it, because they were to make their decision only on what the judge gave them. Then I explained that the prosecution had an obligation to prove that the arrest was lawful beyond a reasonable doubt. Then I challenged them that they should look very carefully through the instructions for anything that would tell them how to figure out whether the arrest was lawful. And if they could not find anything, then the only logical conclusion was that the lawfulness of the arrest had not been proven beyond a reasonable doubt. First moral of that story: always fight like hell for the jury instructions. It's not glamorous, but that in jury selection is where cases are won or lost. Second moral: when the enemy is destroying himself, do not intervene. My mom is a lawyer. She was a judge for 20 years. My dad is currently a judge. I worked at an auto parts store, and the manager is some gross greasy pose who always wears biker outfits and thinks he is God's gift to women. One day his girlfriend comes in. She is beyond nasty. Missing teeth, looks like a meth addict. I decide to put up batteries. He comes back there, puts his arm next to my face resting against the wall. His girlfriend does the same, but on the opposite side of my head, kind of pinning me to the wall. He asks if I want to be in a threesome with him and her. I said no thanks, and he asked me if I was too pretty to have a little cum splashed on my chin, and I bet I would look good with a dick in my mouth. I'm a guy, by the way. I don't say anything for 6 months to my parents. I tell my district manager, and he sends me to another store. Anyway, Thanksgiving rolls around, and him saying something about why I work so far away now. My mom freaks out. She is like, we are suing tomorrow. So she writes a letter saying they punished me because they moved me, and yada yada yada. The EOC denied my claim because of the timeline, 30 days. So she sued and applied for jury. It only costs $60 to sue someone, by the way, and lawyer fees, but I had a free attorney. We went to court. The guy didn't show. Third time at court he shows, and a spokesperson for the company. They start saying I instigated and wanted this and that, and it was me that actually said those things, and the guy's girlfriend was there saying it, and fake crying. So the guy takes the stand and my mom questions him. Well, he decides to say he never did it, and he isn't allowed to do anything like that because 2 years ago he raped a 13-year-old boy, his nephew. It's against his probation. My mom asks all the details and the guy is spilling. He admits that he only likes boys under 15, and since I'm over 25 he is not attracted, so there is no way he could do it. His attorney asks for a recess, which was granted for an hour. The attorney for the company comes up and offers me 10k. I accept, but my mom tells him to go to hell and the jurors just heard this, etc. He then offers 250k, which was also denied. They come back. My mom asks for a long recess of a week, I think. She draws up a new case, asks for the same jurors, and restarts, this time asking for 3.8 million. I did not get 3.8 million, but long story short, I was able to pay for my mom's house, my undergrad, 2 best friends' student loans, about 4 cars. My mom a car, BFF a car, girlfriend got braces and a new car. I lived for 1.5 years in Japan, masters was paid for, my girlfriend med school was paid for, and I haven't worked for private sector in about 11 years. I did PhD research work. I was awarded substantially more than our asking price. One thing to remember when suing a company, 11 of those jurors already hate that company for whatever reason. Not a lawyer, but was being sued by our old landlady. 12 years we rented a place, not a single rent payment late, never asked for anything. Honestly, we were great tenants. Anyway, we had got to the point where we could buy our first place and ask to be able to leave if we found someone to take over the last 9 months on the lease, which they agreed. I had a friend of mine lined up and an offer on a house, accepted when they decided they wanted us to pay for the last 9 months and they would take possession back. We refused to pay as we had everything we had in the deposit for the house and that was just unreasonable anyway. So we moved out, and then a letter came in from their lawyer demanding a bunch of money. I got a bunch of threats from the lawyer bashing me with the terms of the lease and saying how I was liable. I managed to find the lease, read through it, and realize that they had put the rent up in year 1 after 3 months, rather than a full year. It meant we had overpaid every month for 12 years. Not a lot every month, but over 12 years it had mounted up. I countersued for the overpayment. It was very sweet when their lawyer rang me and said that was not in the spirit of the lease, and I remember saying, so what you are telling me is that the only bits of the lease that apply are those that favor your client, and those that favor me aren't in the spirit of the arranged to. They dropped the case and we got our lovely home that we have been in for the last decade. It was pretty sweet to have that small victory. It was even sweeter as they turned away about 5 months of rent they would have had if they had just taken the new tenant as it had all been arranged. Oh, lawyer here. These moments are fun. Here are a few of my all-time faves, representing the owner suing a contractor over cost overruns on a new building. The contractor was a jerk, and we suspected pretty strongly had scammed us outright, but construction projects have lots of moving parts and generate lots and lots of paper, so connecting the right dots can be tricky. In this case, my client had some vigorous email exchanges with the contractor during the project trying to sort out billing discrepancies. After we filed suit, we were able to get internal emails from the contractor addressing these same issues, one of which was an email from the contractor's assistant to her boss saying yes, in fact, one of the charges for renting dumpsters had been double billed to my client. And the contractor's email back to his assistant said, in black and white, okay, go ahead and give him a credit, then just add it back to phase 2 of the project. He'll never notice. We settled that case for enough money to cover the cost overruns and my fees. Another construction project, this time for a new running track at a high school. These tracks are spec'd out with very exacting standards for grade, pitch, surface imperfections, etc. Local asphalt company won the bid, came out and laid the track, and did a sheet job. Don't get me wrong, it looked gorgeous to the naked eye, but when we had the surveyor came out and check the specs, it was awful, literally hundreds of small imperfections, small dips and bumps that you wouldn't ever notice in, say, a parking lot, but that left the track absolutely useless for competition. The survey was color coded to show all the imperfections, looked like the track had measles, chickenpox, and acne all at the same time. Cost us twice as much to have another company come out and redo it. After filing suit, we got them into mediation, using a retired judge who remains one of my all-time faves, whip smart down-to-earth no-nonsense type. I showed him the survey, and his jaw dropped. He couldn't hardly believe the contractor was wasting everyone's time fighting this. Got into a room with the mediator and the contractor, a little Winnie type, and the mediator asked for his position, and the guy insisted they'd done a great job, pulled out a bunch of photos that looked beautiful, to the naked eye. But what about the survey? The mediator asked. It's all out of spec. Contractor denied ever seeing any survey. Taken aback, the mediator turned and started to reach for the survey I had just shown him. Well, the contractor whined, I haven't seen one that was done correctly. This judge/mediator turned on this guy and just laid into him. By the time he was done, we had every dollar paid. Last one, high school student was hurt in PE class. She had some really bad pre-existing back conditions, had already been through 3 surgeries by high school. It was quite sad actually, but after the surgeon released her to rejoin PE with restrictions, she hurt her back just a week in and finally needed a fusion. They tried to sue the school. She claimed that the PE teacher had made her do things against her restrictions, that a pilot stretch was hurting her back, but she kept doing it anyway. But, your #1 rule, which the doctor told you, and the doctor testified about, and which you acknowledge, was always to stop if it hurt. Why didn't you stop? Why didn't you tell the teacher it hurt? Well, the teacher hadn't really made her do it on the day if, just that the girl did it out of fear she would get yelled at again. Like the very first day of PE, when they made everyone run laps, and the teacher yelled at her for walking, because she could only walk. But the teacher testified that there was no activity at all on day 1, because kids were being issued lockers. They couldn't even change into gym clothes yet. Oh, right, must have been day 2, then. Actually, day 1 was locker assignment for the first half of the alphabet. Day 2 was the second half. Day 3, I guess. Actually, you were excused on day 3, because you told the teacher your back hurt while stretching. And so on. There were only 5 days of PE before she got hurt, and none of them involved running. Well, mom testified, the doctor changed her restrictions. After she started PE, she wasn't supposed to do any stretching at all. Time out. Did you tell this to the school? Yep, emailed them the day before she got hurt. There was, indeed, an email exchange from that day. I showed it to her. Nothing about new restrictions. Well, must have been an email from Monday. But didn't you talk to the doc on Tuesday? Maybe I talked to the doc on Monday? We go through every single email exchange between her and the school. On the stand. In front of the jury. There weren't many, it had only been 1 week. And surprise surprise, there wasn't shit about the doctor changing any restrictions. Well, I guess I must have forgotten. I was really busy at work, you know. Bingo. Judge denied my motion for directed verdict. Said jury still needed to assess credibility, but jury brought back a verdict for the school. Not a lawyer, but I broke up with a divorce lawyer once, and she made my life hell. The day after I broke up with her, she filed a restraining order against me. I'm still not sure what grounds she gave for the judge to grant it. I wasn't allowed to go back to our apartment until I went to the hearing to see if the restraining order would be made permanent. I did what any other stupid 20-something might do. I sent my friend to the apartment with a copy of my lease and a locksmith to break open the door. My friend gathered all my things and brought it to my mom's house, where I was staying. 4 hours later the cops showed up to arrest me. I thought my friend might get in trouble, so I kept my mouth shut and asked for a lawyer. A couple days later the restraining order was tossed out due to me being deemed a non-threat. Somehow my ex convinced the prosecutor that allowing me to bail out of jail would put her life in danger, so I sat in jail for 8 months refusing to plead guilty. The day of the trial finally came, and my public defender absolutely wiped the floor with my ex and the prosecutor. My favorite moment was my lawyer asking my ex on the stand, "Lawyer, has this man ever harmed you?" Which, well, no, but, lawyer, has this man ever threatened you? Physically or verbally? Which, well, no, lawyer, have you ever feared for safety from this man? Which, well no, but, lawyer, then why the hell are we here, and why have you let this man sit in jail for 8 months? No further questions. It Took the jury 20 minutes to find me not guilty, but she stole that entire year from me purely for revenge. Don't date lawyers, kids. Not a lawyer. Hate to say, my brother's ex-wife wanted vengeance against my brother when he told her that he was cutting her off and she needed to pay for her own rent and childcare for her 3 kids that were not his. His only daughter with her was about to turn 18 and child support was officially over. He refused to pay for all 4 kids. The ex-wife and boyfriend, father of 3 kids, both adults who were happy to sit on their ass and do nothing as my brother paid for their needs while living very frugal. So the night that he told her he was cutting them off, offering to let the daughter come stay with him, she told their daughter that her siblings would be homeless and starved to death especially when she left, and convinced her to come to the police station and say that he raped her twice on 2 different dates. He went through hell with the courts to prove that he didn't, and surprisingly his boss came to his rescue. My brother was a truck driver. After verifying the dates that were on record, the boss checked his logs and found stamps that he was in TX on one date and CA on the other. They lived in the Northeast. After talking to the yards, he was able to get a photo of his truck pulling in time stamped and a photo from a video at one yard of him getting out of his truck for delivery. They asked his daughter again and she was firm. They dropped the evidence and the ex freaked. The daughter had a meltdown and admitted not only that her mom told her what to say, her mom also had her forge my brother's signature on a government document and their rental agreement. And now ex-wife and daughter are facing possible charges for forgery. I work armed security, so not a lawyer. However, I'm almost positive that I gave the lawyer handling the case against my boss this. I'm compulsive about sire. Paperwork is filed away when not used. Chat messages are screenshot and stored on a cloud. All phone calls are recorded. Yay for one-party states. And my company issued and personal body cam were always recording when working with the contents dumped to my computer at the end of the day. During the free consult I explained I had time-stamped screenshots of him admitting we weren't paid for being on call. The company handbook saying all guards had to be on call 24/7. Text messages that went out to all the guards saying that our checks were delayed 3 times in a row. I don't think the guy could have jumped on my case any faster, even offering to reduce the contingency fees by 10% and no out-of-pocket expenses. All told, the flash drive I gave them when they took the case had about 30 GB of video, audio, and document proof for the case. There was even a copy of the transcript from my brother-in-law's final work camp hearing where our boss tried to weasel out of paying by saying he was off the clock because we didn't get paid while training new guards. Second longest part of the case was serving my boss notice. Aside from being a cheapskate, he was sleazy as hell and had admitted in the office with half a dozen people present with body cams on that anytime he got mail from a law firm he either shredded it or had it returned to sender. The longest part of it has been getting the judge to sign off on the settlement of what became a class action lawsuit by all the employees past and present, which is still pending either due to COVID or because the judge is reluctant to bankrupt him when he's being sued by at least 2 other parties for fraud and intentional breach of contract. Sorry for the length. Tried to keep it as short as possible. My family is scattered around the country, so most of this happened by email and phone calls. I have 4 sisters and none of us really spoke to our dad very much. He would call one or another of us every once in a while, but we were not close. I loved my dad deeply, but he was very controlling and none of us would allow him to control our lives, so we kept our distance. When dad passed away, 2 of my sisters went to where he lived to handle final arrangements and sort through his stuff and basically take care of everything. He lived in a retirement community and owned his condo outright. He also served on the HOA for the community. When they got there, his neighbor asked who they were, and when they said we are his daughters, the neighbor responded with he doesn't have any family. Dad was always a very private person, so we really didn't think that much about it. We had the access to the condo, keys and such, so they didn't worry too much. During the cleanup, on sister found a letter dad had written, addressed to her, that explained where his will was. We figured he realized he was getting near the end, and some other instructions about items he wanted to go to specific people. No problem, they found the will and turned it over to a lawyer they hired to take care of everything. One other item they found was a box of HOA documents and they weren't sure what to do with it. The neighbor offered to take it and get it to the secretary of the HOA, so the problem is solved. They both went back home, and a couple of weeks later one of the sisters gets a phone call from the lawyer that there is another will. It was found in the box with the HOA papers. We asked for a copy, and it shows leaving everything, bank accounts, the deed to condo, car, to someone we didn't know. It was notarized and everything. We did some research and found the person who notarized it and contacted her. I asked her if she knew my dad and she did. The bank she worked at handled the accounts for the HOA. Then I asked if she ever notarized a will for him. Her response was she had never notarized a will in her entire career. We gave all this information along with her contact info to the lawyer, and then a few days later got a call from the state attorney office and they confirmed that the second will was a fake, and it opened up a ring that was stealing stuff from people who had passed away without any family. Apparently, they had been running the same scam for about 10 years. My dad's real will left everything to his grandkids and all of us, his daughters, were absolutely fine with that. Guess I'll add my weird story. Was at an eviction hearing after my brother passed. We had asked the judge if it would be okay for a court reporter to be present due to other issues we've had with the tenant. Judge didn't want to take too long on the case or something and declined our request. Here's the fun part. Questioning goes as follows. Name, residence, why you believe you hold any claim to the estate's property. Pretty basic, except the tenant began screaming that the attorney was berating him and other nonsense. By the 5th question the guy's own attorney begged him to stop acting in such a way or else he would quit. By the 10th question the judge wanted to speak with the attorneys in his chamber. The judge apologized for declining our request of having a court reporter present. The guy was acting crazy. Then, in the middle of all this, the guy claimed my brother's will stated he was allowed to remain in the home, he just couldn't own it. Lol. My attorney asked for this will since the estate was in probate. Guy stated he only had a photo of the will, but something is better than nothing. It was one of those wills you can print off the internet, but he added X could remain in the property until X date. The will had no signature, of course, but the receipt he provided from my brother's credit card statement had a date after my brother's death. That poor judge just put his hands on his face. He couldn't believe it. I think he broke that judge. Lol. Ruled in our favor. Crazy guy. My brother was trying to help clean the house out, even called my mother and laughed about my brother's passing. So don't do drugs, kids. They make you crazy. I was working summers as a file clerk in a law firm. This woman was suing a client of the firm and representing herself. She literally filled out paperwork in crayon. The system was cutting her a lot of slack. So they have a deposition in one of our conference rooms. I'm in a little file room filing stuff. 2 secretaries and an attorney walk in and lock the door. They had deadbolts on the file room doors. I kind of look at them. It turns out the secretaries had gotten calls that told them to get their attorneys and lock themselves in the file rooms. Yes, the attorney offices had big doors with locks. They also had windows with curtains from the hall looking into the offices. The file room doors were solid, but the same color as the wall. I'm guessing they thought anyone on a rampage would be focused on the executive style attorney offices. Close bracket. A little while later, we get an all clear call from the phone in the file room. So we are wondering what the hell. The next day one of the secretaries comes in and tells me what happened. The crayon lady had shown up with another woman for the deposition. The woman was in a flowing dress/robes. The other people involved thought, good, she finally got an attorney. Nope. In the middle of the deposition, the second woman pulls a doll out of the robes and a big long needle and starts talking under her breath and sticks the needle into the doll. Someone asks what the hell is going on. Crayon lady, I hired her to kill all of you with a curse. This being Texas, they assumed a gun might accompany the curse, so lockdown. The elevators to our floor were also turned off. Cops come to escort the women out. There is some procedural stuff, but the case is thrown out. Everyone directly involved was given a week off. Technically for missing deadlines or something. Not a lawyer, but a witness to a terrible car crash. A massive truck, talking like Dodge Ram King cab, dually tire, extended bed, etc. A beast, runs a very red light. By very red, I mean, it was about to turn green again for him. An incoming truck in traffic, think, tiny 1992 Nissan truck, hit the side of the big truck. I was on the other side, so I didn't see who hit who initially, causing the big truck to literally do a 900-degree spin in the intersection and end up in the ditch on the corner of the intersection. My car, and everyone else's, had truck debris thrown at them, so I pull over, tell the cops my story, and write a witness statement in case any damage was done to my car. There wasn't. Setting the scene a little, at this time, 2009 to 2011 I think, we had speed trap cameras in my state. On main roads, near schools, on the highway, etc. Everyone got tickets sent in the mail and ignored them, and some people got their licenses suspended for getting too many without their knowledge, because they ignored all the contact. I had gotten one ticket during this time period, and I was scared I had more. I missed point. Fast forward over 2 years later, I receive a court summons that I didn't understand. I was like 20 at the time and all I saw was a so and so vs such and such names. I was scared. I thought I got another ticket when my license was suspended without my knowledge. That I was like, is it worse to not go? I went to the court on the said date. I find the room they tell me to go into, and I'm there with like 12 other people who had been chatting it up this whole time. They asked me why I was here. I said I had no idea and they stated, oh no doubt, it's the licenses from the speed trap cameras. I thought, shit, they are just informing us in batches or something. Finally one last person enters the room and the same scenario happens. The guy turns and is like, nope, you guys are here cause my lawyer requested it. And the 13 of us are like, but why? And he said, because you guys filed witness statements for the accident that happened 2 years ago, and we all were like holy shit, our licenses were fine. The aha moment came for that guy's lawyer when we entered the courtroom and judge asked who all these people were. The lawyer calmly, with a slight smile, says every witness who signed a witness statement at the crash scene. The judge rattled off a few things I didn't understand. We all left and came back 15 minutes later. The judge asked the defendant's lawyer if he agreed to the bench trial verdict that his client was guilty of taking painkillers and sleeping pills while driving, and they agreed. The judge also commended the other lawyer for gathering every witness, which he had never seen before. It was bonkers. In a hoe. Super late to this, but I will throw my story out there. Obligatory INL, but was the defendant in an eviction case. I had fallen on some hard times at work with hours being cut, and was about half a month behind on my rent. Rent was due on the 1st. The rental company filed very early for eviction such that, if it wasn't in by the 15th with all late fees, there would already be a date scheduled for an eviction hearing late in the same month. I lived in an area that was heavily biased in favor of the property owner, but even with that in mind, filing that early is very uncommon. Usually most places give you more time before they go through the process of eviction. I went to the rental company and told them that I was going to be later than the 15th due to an issue with electric bill being insanely high in the house due to things that were the property owner's responsibility. The water heater not being properly maintained in years and the air conditioning unit in similar condition, and due to when my checks fell in the month. Because of these things the electric bill came out to over $500 for 1 month, and since I have kids I could not have it cut off. Basically I told them I could pay 80% of the rent before the 15th, but would need to wait for my next check for the rest plus all late fees. They filed for the eviction anyway, but said that if I brought in the agreed upon amount they would cancel it in good faith, and we could go ahead with the agreement we had made. I, being young and dumb, took them at their word. I confirmed this again on payday, then brought in the money order, filled it out to them as instructed. I was then handed papers that day to appear in court for the eviction anyway. There are other reasons for this, but they are not strictly relevant to the story, so I won't go into them here. The court case was surprisingly quick, scheduled for before my next paycheck, when I would have paid the rest of the debt off, so the day of the court case he dropped by the house to give me back my money order for what I had already given them. When we got to the courthouse I told my lawyer this. We had gotten a lawyer through a local non-profit who help with these sort of things, and were only meeting her for the first time that day, and her face lit up. Turns out, there is a law on the books in my area that, if the rental company accepts a partial payment, after having filed for eviction, it is considered to be a tacit agreement of a payment plan, to bring the debt to current. My lawyer brought this up immediately to the judge. She outlined how they had accepted it after having filed, and even how they had stated that, if I paid they would cancel the eviction, then failed to do so, then brought up the fact that they had made me fill out the money order to them, so that no one but them could possibly cash it. The judge said that this was clearly an intent to handle the debt out of court and to maintain the business relationship, and made them pay for the court date themselves, and refused the eviction. The property owner and his lawyer were both chewing the property manager out as they left the courthouse. In Canada we have a constitutional document called the Charter of Rights and Freedoms, which outlines citizens' rights and protections when dealing with the state. One of those rights is to be informed promptly of the reason for your arrest or detention. The courts have interpreted this to also mean that the police must advise a detainee of their rights in a meaningful manner, otherwise evidence collected thereafter can be excluded. Anyways, I had a client who only spoke Arabic that was caught for a DUI leaving a strip club. Client literally didn't speak a word of English. When I met with him, he brought his friend to interpret, and I had a hard time even understanding his friend. We ended up communicating by typing into Google Translate and passing my laptop back and forth. So I made an application to exclude all evidence collected after his arrest, including his breathalyzer results. Because his rights upon arrest weren't communicated to him in a manner that he could understand, police made no effort to get an Arabic-speaking officer to speak to him, and he clearly didn't understand their English dialogue. A few days after I made the application, the prosecutor contacted me and said, "Is this application legit or full of shit?" I said, "What do you mean?" He asked, "How bad is his English really?" When I told him I met with him the other day and his interpreter needs an interpreter, he said all I needed to hear and dropped the charges. Not a lawyer, but this happened to my friend during his custody battle. The mother was trying to claim full custody of the child, which was barely over 1 year old at the time. One of their big argument was the daycare and the distance. When they were together, they lived in Town A, but after the breakup my friend had to move in back with his parents in Town B, half an hour apart, and apparently this caused problem for the daycare. She wanted to send the kid to a daycare as far away from Town A as possible, clearly just to make things complicated for the father, while father compromised with another daycare, but really wanted to keep the child at his parents' house to be watched over by them. So the mother goes first, whining about how she had to take the child to her workplace while she worked because the father wouldn't budge on the daycare. Her lawyer asked, "Isn't it unusual to do this?" "Yeah, but I know paternal grandfather does the same. When child is in father's possession, doesn't Mr. Grandfather work at a mechanic workshop? That's not a place to bring a child." So this is the gist of the mother's arguments. Father was too busy with school and work to properly take care of the kid, leaving her in the care of a grandfather who brought her to a noisy workshop. Later it was grandfather's turn to take the stand, and his has a smirk on his face. Lawyer, "Is it true that you work at ABC Mechanic at address?" Grandpa, "Yes, I'm the owner." Lawyer, "And you watch over child while father is busy at work or his studies?" Grandpa, "Yes." Lawyer, "So you bring child to your office at ABC Mechanic?" Grandpa, "Yes, but no. I'm semi-retired, work about 15 hours per week and only perform administrative tasks. I set up an office at my home so I can watch my grandchild." The mother had tried to paint my friend as too busy to take care of the child, and all she managed to achieve was show that my friend had taken all steps to ensure that their child was surrounded by loving family. There's more, but in short, the judge told her to quit her bullshit in judge speak. It was a winning plaintiff in a civil lawsuit regarding real estate non-disclosure. When you sell a house in the US, state where I live, there is a very detailed form you fill out, noting all of the problems or defects that you know of regarding the property. Despite the understandable desire to gloss over any issues with the place, it is very much in the seller's best interest to fill these out honestly and correctly, because if you lie about it and get caught, the buyer can sue you for triple damages. The seller owned the house for about 12 years, and at some point they discovered a major structural/water intrusion problem which would cost a lot to fix. Instead of being honest about it, they decided to cover it up and lie about it on the disclosure form. After we bought the place, we discovered both the damage and the cover up. The concrete foundation of an exterior structural wall had cracked, failed, and was slowly collapsing. This jeopardized the structural integrity of the house and let groundwater run under the downstairs floor, rotting out all the layers of flooring beneath the newly installed top layer. Instead of fixing it, they built 2 false walls inside to hide the collapsing foundation and covered up the rot beneath with a new layer of pergola laminate. So here we are just a month after purchasing this house, looking at a $50,000 repair bill to fix a major problem that the sellers had obviously discovered, chosen not to fix correctly, made substantial efforts to cover up prior to the sale, and then lied about on the record. You will never find a lawyer who will take a case like this on commission, since it usually comes down to a he said, she said situation which is nearly impossible to win. In this case, however, we had hard evidence showing the date that the false wall has been built right in the middle of the previous owner's tenancy. It turns out that drywall has the manufacture date printed on the back. Fiberglass insulation has the manufacture date printed on the paper facing. Romex electrical cable has the manufacture date printed on the plastic casing around the wires. All of these dates agreed, indicating that the false wall was built by the sellers about 4 years prior to the sale of the house. After multiple failed attempts to settle, we ended up in court, both sides paying for expert witnesses to prove our opposing theories about how the false walls ended up there hiding all that damage, and specifically, when they were built. They paid about $10K for the elaborate piece of fiction that their engineer/expert witness came up with. I know, since they tried to get us to pay for it. He had a complex theories about how we must have caused the foundation to collapse. When confronted with the inconvenient dates on the various construction materials, he came up with even more elaborate theories on how electrical wiring, fiberglass insulation, and drywall would have somehow been installed behind a tiled bathroom wall without the knowledge or participation of the sellers. The kicker was that this expert engineer had never once stepped foot in the house. The opposing counsel had a baby in the middle of all of this, so the defendant's expert had over 6 months' time in which he could have examined the house in exhaustive detail, but he never showed up, not even once. Our attorney asked him why not. He asked him, have you ever even laid eyes on the house? The expert's answer was yes. Yesterday morning I took a look at it from the street. You could see the judge cock his head a bit, and he asked him, why would you do that? The expert's answer was, because I knew you would ask. Our attorney was an abrasive, irascible curmudgeon of a man, but at that moment I saw the biggest smile light up his face. He turned his head and just smiled at us for a few seconds, and then slowly shook his head and told the judge no further questions. At that point everybody in the courtroom knew it was over. The defendants dragged it out as long as they could, but 2 days before the deadline for the judge to render a decision on damages, they showed up with a check. It wasn't enough to pay for the reconstruction, especially after taking out the legal fees, but at least we weren't on the hook for all of it. We still live in the same small town, and neither the opposing counsel, the defendants, or the expert will meet our eyes when we see them around. TLDR, when you sell a house, don't lie on the disclosure statement. It's better to get paid a bit less for the sale than to piss away tens of thousands of dollars in legal fees and damages if you get caught in the lie later on. I was a prosecutor, and one of our jobs was doing the involuntary commitments. People being placed into the state mental hospital when they were deemed a danger to themselves or others. The judge always made people wait on him. If court was at 12 noon, he would enter the courtroom at 12:20. The lady being committed was wearing a blanket, nothing else, and was incredibly agitated. She was screaming at everyone in the courtroom. The judge also wore a really bad toupee. Judge enters 20 minutes late. The lady being committed goes off on the toupee yelling that he had a dead animal on his head. This goes on for a few minutes. She has been calling her attorney and me racial slurs for 20 minutes at this point, and she started using them on the judge. Her attorney asks me to move to have her removed. I said no, she is proving my case. About 20 seconds later, I moved to have her removed when she stood up without the blanket. She was committed. She came back a few days later, after having been given her meds. This was a long time ago. I do not remember if it was 72 hours later or 2 weeks later, as there were reviews at each time period. She was the sweetest woman ever. When she came back, she had really bad mental illness that was well managed on meds, but she stopped taking them for a few days, causing her mental breakdown. Not a lawyer, and not me, but my mom. My mom had me at 17. Things did not work out between her and my father, and she had my brother when she was 20 by another man. They married, but she quickly realized he was a complete deadbeat. He absolutely did not work, among other things, and started the process for divorce. Now I was only about 5 at the time, so my details are a bit fuzzy, but essentially he refused to sign the divorce agreement and sued her for custody of myself and my brother. It was quickly brought up that I was neither biologically his or adopted by him, that my biological father had already made an agreement with my mother for child support and visitation. This guy then tried to claim that I could be his. Not a frigging chance. He literally wasn't in the country, but also he was 6 years older than my mother, and she was a minor when she had me, so that just seems like a bad idea even were it true. And then when that didn't work, started on about how he had supported me financially, so he had a right to the child support my father paid. So he was asked to show proof of this financial support, to which he said he hadn't had a job in some time, try 8+ years, but he was thinking about joining the Army Reserves. At this point it is made clear to him that he has no claim to me whatsoever, but that they can proceed with regards to my brother. It is at this point that my mother's lawyer brings in the 3 other mothers of his various children that he owes many thousands to in child support, who all had evidence proven in court previously of his abuse, neglect, and general sheetheadedness. He did not get custody of my brother, but tried many more harebrained schemes to get custody even after my brother turned 18. This included, but is not limited to, claiming my brother on his taxes, calling DCF, DSS at the time, at least 3 times a year, taking my brother from our yard a few times, taking my mother to court to have his child support payments lowered, and seeing as he owed her, and now I believe 6 or 7 others. This always backfired for him, kidnapping my brother, and taking him many states away. Calling me to ask that I speak on his behalf. I wrote a detailed letter of his atrocities for the court a few years back, so I truly don't know what he was thinking on that one, and running away to his mother's home country several times, where he has been repeatedly arrested at the airport and sent back to the US. He always lies to his lawyers, so they are often completely thrown, and I believe one lawyer from a while back is actually suing him for something, but I never untangled the story from my brother. I would suspect he just didn't pay the guy. Not as a lawyer, which I never practiced, but in the case of my dad vs my sister's mom, there were a lot of gold mines. My sister's mom sued for legal alimony. Now my dad is a questionable guy, but he's never been late with any kind of money. He never fails to provide financially points, so this was mostly a how much can I get type of thing. My sister is unfortunate in having 2 crazy parents. I only get half the craziness. But somehow in this trial, her mom took a huge prize in the crazy league. Her main argument was that my dad abandoned her during her pregnancy, and during the case she was giving countless examples of being left alone at home and how she felt lonely, and then she finished with, at that point I thought it would have been better to stay in my own house. So the lawyer asked something like, so you're saying you moved in with my client? Well, yes. He said it would be better, but he was always working or spending time with his kids. At one point I decided to go on holiday with my friend to forget about it. So you're saying that my client's abandonment was actually him going to work or spending time with his other children, and that you, who claim you were too weak to do anything, went on holiday where you took these photos? Proceeds to show photos posted on her own social media of her running, hiking, and playing human football. No. The rest, as they say, was history. They settled for alimony, but she has to show us her expenses so far. 10 years later, she still hasn't done so. During closing argument, old man defense counsel used a football analogy against young lady me. Case came down to a threshold issue / crossing an imaginary plane. No doubt his client did it, and he was desperately arguing the crime never happened, hinging his entire case on the meaning of in point fired up. He starts talking about how in college football a player's foot must be entirely in bounds when you catch the ball. He's jumping up and down, catching an air football, his twinkle toes towing an imaginary line. He stresses if any part of the player's foot is out of bounds, the entire foot is considered out and not in. No touchdown. Game over. So I stand up on rebuttal, standing firmly on 2 feet, and reach my arms up and out to catch that air football. Firmly on 2 feet as his client had stood. Reached my arms up and out as his client had. I caught that ball standing firmly in defense counsel's end zone, but with my arms stretched beyond the imaginary sideline. I pulled my arms in and hugged that ball close. My arms may have been out, but I was in, meaning the ball was caught in. Touchdown scored. Jury sold. Still, I reminded the jury that rushing players often reach out to get the ball across the goal line before their knees touch the ground, because if any part of the football crosses the goal line clean, it's in, even if just the tip. I sat down without another word. Defense counsel had his head down, and he was fighting back a smile. Not a lawyer, but hilarious nonetheless. Someone I'm close to had a nasty 7-year divorce battle with his borderline personality disorder ex-wife, involving custody of 2 children, 6 and 11-year-old. When the case began, it began with Borderline Beach going to a charity for abused women seeking legal advice to pregame for her upcoming divorce. There was never any evidence of abuse, no police reports, no statements or testimony from experts, no physical evidence whatsoever. Nonetheless, she was granted an order of protection and her spouse was forcibly removed from his home by police serving the order. She took the initiative in the case by securing sole custody of the kids. Based on these events, the initial battle for my friend was getting visitation rights, then battling over the course of about 12 months for partial non-custodial custody, then finally getting the protection order tossed so he could get his confiscated property returned. He collected and safely stored guns. After that, Borderline Beach changed tactics to drag everything out, thinking she was getting county legal aid and he was paying out of pocket, so he'd run out of funds and have to concede to her demands. He did run out of money and had to represent himself for a while, but didn't give up and found an attorney to help him at minimal cost. Still ended up being several $1,000s though. After about 3 years of this sheet, Borderline Beach started making mistakes. She drove her kids around while drinking wine. She made threatening calls to voicemail and texts. She hired a private investigator to follow her ex and record him breaking court orders, which he didn't. Lol. About 3 years after that, the deal breaker for the judge was when Borderline Beach tried to contact the Dr. Phil show and literally try to move the divorce proceedings onto syndicated TV. There were wild claims like that my friend was a contract killer and some other pure lunacy. Upon hearing this, the judge was simply flabbergasted, suffering from aposiopesis. When she regained her faculty for speech, she awarded my friend full custodial custody and gave Borderline Beach the same visitation arrangement that was originally forced upon my friend. Borderline Beach doesn't have any relationship with her fully functional, but obviously traumatized, adult children anymore. Not a lawyer but a paralegal. Not all screw-ups happen in court. We received a box of discovery from opposing counsel in one of our workers' comp cases. The case was not unusual and shouldn't have that extensive of a history, so I was surprised by the size of the box. For my job, I open it and start organizing it for my attorney, knowing what he needs to see and what just needs to be put in the file, etc. It's a typical mess. Papers all over the place in the timeline. Photos mixed in random places, etc. Lots of things duplicated. It's not typical, but sometimes an attorney will do this to bury the other side in paperwork, so they don't go through the whole thing and may miss something important, because it is not a complicated or long case. However, I'm meticulous. About halfway through the box, I realize they sent their entire file. Stuff they shouldn't be sending, like notes from interviews with their client, internal emails. This happens. In this particular case, we probably wouldn't find a smoking gun. I asked the attorney what to do, since it was all mixed together. He told me to pick out anything privileged and set aside to send back, and he would draft a letter, but he didn't want to see it. Perfect response. He was awesomely ethical. However, as I went through the rest, I discovered that wasn't all they sent us. They sent us the entire file on a completely different person who was not our client. I have no idea if it was their client being WC sued by two different employees or another client of Fizz altogether. Also, it was incredibly personal info about medical social security number. The works this time the response was, pack it all up. Every paper. Seal it. Label it. Put it on my desk. I came in with the box to him yelling at the secretary for opposing counsel who was telling him the attorney was too busy to speak with him. He basically told her, unless he was on the toilet or in front of a judge, get him on the phone now. I did not get to hear the conversation, but he hand delivered the box to them that day. 2 days later they settled. Fair settlement for both sides. I'm sure someone in that office got fired. Not a lawyer, and not a law case, but I defend friends at employment tribunals as a side hobby. Won every case so far, don't let them bully you. In this case it hinged on whether the hours member had reported the allegation onwards or instead ignored it till the morning after. The hour person in the submission stated she took the allegation seriously and passed it on to her manager same day, so we requested the email which we knew they didn't have. Hours responded 2 weeks later that they could not produce the email as she had alerted the manager via phone. First Strike, as their own policy said, it must be passed on in writing. We therefore requested, as it's an IP-based phone system where users have to sign in, the call logs to show the time of the call, which we knew they couldn't. Hours responded 2 weeks later that they couldn't produce the logs as the call was made from a mobile, not the works phone system. Second Strike's works phones are not to be used for sensitive hour work according to their own policy. We asked for the works mobile phone call records to show the call times, which we knew they didn't have. Hours responded 2 weeks later saying they can't, as the member of staff used her own personal mobile to call her boss to report the allegation once she had left the office outside of works hours, thinking that blocked us as we could not request those records. However, they had, seemingly unknowingly on their part, gone from defending a minor transgression, went home instead of reporting, to admitting 3 breaches of their own policy, which damned them at the hearing into a 5-figure settlement to hush it up. Not a lawyer, but was in an accident late at night where I changed lanes at night and got partially sideswiped, rear-ended almost immediately. We pull over, I make sure my passengers are alright, and get out to see how the other driver is, thinking, damn, I'm at fault. I must not have seen them in the other lane. I start exchanging numbers and calling insurance with the other vehicle's driver. Then a cop shows up, and I figure someone has called. No big deal, I'll own it. Cop stops me about halfway through my mea culpa of I guess I just didn't see them. I'm sorry, when she says, I know you think that's what happened, but I was hiding on the side of the road and have watched all of this unfold. The person claiming to hit you wasn't the driver and they were speeding at some insanely high speed. I'll be back, stay here. Suddenly, feeling good about my odds and pissed that I was almost duped. Cop comes back after having arrested the 2 people in the other car. The woman claiming to be the driver was actually 19 and said she was driving for her boyfriend who was drunk. After the cop issued sobriety tests / breathalyzers, she confirmed he was in fact drunk, informed them that she saw him driving them switch before talking to me, and oh, by the way, the 19-year-old girlfriend, while not above 08 back, also had alcohol, and that was illegal for someone underage to have any alcohol and drive. Oh, by the way, you also lied to law enforcement. I assume not under oath, so who knows if that ever amounted to anything, but it sure pissed off the cop. A few months later, she called me back saying her court-ordered rehab program needed some information from me, and she needed to complete it in order to avoid prison time. Justice was served. Null Point requested a restraining order on my ex's ex. The beach was bonkers. She told people I was stalking her, threatening her and the baby she was pregnant with, claimed that CPS had taken my children away, and went on a social media crusade against me. None of this was true. I never had an issue with this chick at all. She was doing this to punish my ex, and she had us both blocked, so she thought we wouldn't see her posts. We had mutual friends. They sent me screenshots She had her mother, sister, and several friends threatening me with violence and destruction of property, and talked about how she needed a restraining order against me. In the county she lives in, you have to have the person's full name, birthday, and address to file a restraining order. So they claimed in those posts that they found my address, but didn't have my birthday. Them finding my address led to more comments talking about vandalizing my stuff or assaulting us. That was enough for me. I went and filed my own restraining order. I knew for a fact that they weren't filing anything against me. There was no reason to. There were no calls, no interactions, no messages in the length of time that she suddenly took issue with. This was 100% her trying to rally her people into attacking us because she had tried and failed every other way to control my ex. Also, I'd called victim's advocate in all the surrounding counties and confirmed that she had done no such thing. So I forwarded all of my evidence to be reviewed before the judge court covered. I also invited the judge to request anything else from me because I had specifically maintained proof of every interaction I'd ever had with her, including recording the one phone call I ever had with her. I had an abundance of proof. I didn't get my aha moment. It wasn't in person, and neither of us made any sort of arguments. The phone call lasted 30 seconds. The judge confirmed that we were both on the line, asked her if she has any objections to him filing the restraining order, and she said no, sir. My brain went, what? She was agreeing to the restraining order? There was no aha, just a what the fuck? And then the call was over. I'm not sure if maybe she was confused and didn't realize that meant he was granting it if she didn't care anymore, since by the time it went to court my ex and I had split for unrelated reasons, or because she knew for a fact that the proof weighed heavily in my favor. But she agreed to the restraining order immediately, and the call was ended. I had to call the court back half an hour later to be sure I wasn't missing something that the judge had decided in my favor. Yep. The call truly was around 30 seconds. I was still recording calls at that time. It was over too fast for me to even process it had happened. Worked for a terrible company getting paid minimum wage for a job that should have been double that. Super aggressive micromanager Karen of a boss. Did some training here and there, which I didn't really ask for, but she insisted on. After around 18 months I decided to leave as I couldn't take the stress anymore. She then tells me that I have to pay back all the training costs, estimated to be around 4k, even though most of that was in-house and technically didn't cost anything. Told me it was in my contract. Checked my contract, and it says, should you undertake any training and leave before 5 years have expired from your start date, you will be made to pay back training fees. You are required to sign a training contract that makes this legally binding. As legally dubious and probably illegal as this sounds in itself, I was never asked to sign a training contract. She assured me that it didn't matter and it was still legally binding. She even had her hours dept send me a threatening email stating that the contract still stood. As much as I believed her hours dept that she was in control of, I decided to get outside counsel. I basically highlighted the text in the contract that clearly showed in black and white that I didn't sign a training repayment contract and had a lawyer write up my own threatening letter stating that she had no legal recourse as it was clear that any training contract had not been presented, reviewed, and signed. She wasn't happy about it, but had no choice but to back down. Always read the small print. And also, maybe don't get the girl in your office to write up and take care of your legal contracts. Not an attorney, I found myself having to file for custody of my son after my ex-wife never bothered to pick him up after visitation. In fact, this was a pretty common thing, and I'd had enough. I loved my son being with me, but hated it when she'd turn up a week or so later and act like I did something wrong. I go to court, file the motion, get a court date for an initial hearing a couple hours later. I give the court my info and hers. I had planned to go to court and ask for a continuance to secure counsel. I'm sitting in the lobby waiting when I see the sheriff deputy escorting prisoners down the hall while the door was opened. I didn't think anything of it. My case is called, and when I walk in there sits my ex-wife in an orange jumpsuit and chains. When I saw that, I just spoke my piece. Turns out, when they ran her info, they found she was in jail and served her there. She had been sentenced the day prior to a stated 180-day sentence, with an additional 75 days to complete a drug program. It was a slam dunk. The judge signed to order and said good luck. My ex was pissed, but the judge was too friendly to her situation. She wanted her mom to take my son. That didn't happen. When she got out, she filed for custody again. Turns out she dropped out of the drug program, and that was brought up. She also was ordered to pay child support. She died when my son was 26 and never paid a dime in support. I never thought she would. Her dealer would get paid before my son. Turns out, I was right. Not a lawyer, and not technically a court case, but I did catch someone lying about an insurance claim on me. When I was 17, I worked at Whataburger with my friend who lived with me at the time. We were going home after school to change into our uniforms before work, and this truck slowed down really fast to make a turn and I couldn't stop fast enough. The accident was my fault 100%, and I paid the ticket without complaint, but I would barely call it a collision. I was almost at a stop when I hit him, and being in Texas, he had a huge trailer hitch that saved him from getting a scratch, while the bumper of my Kia Rio was done for. Q, who had never been in an accident, started having a panic attack. I tried to calm him down, while the old couple in the truck gets out and yells nice things like, "Were you texting? I bet you were texting. Is he on drugs?" I ignored them after apologizing for the accident and waited for the cops. The cop gets there and asks them if they're okay. The husband says, actual quote, "Yeah, but who knows, my back might start hurting in the morning." Him and his wife chuckle. I thought it was a joke, albeit not very funny to me. So a couple days go by, I pay the ticket etc. and then I get a call from their insurance company telling me they're filing personal injury. I go great, because I can't really defend myself against such substantial evidence as my back hurts. So I didn't fight it. I paid it. My insurance payment went up. Life was good. But I still had a hunch they were lying, but no way to prove it. I just wanted the satisfaction of knowing I was right. LMAO. I never imagined I actually would. My chance came at work a few days later, when the husband walks into Whataburger for lunch. I waited in the kitchen where he couldn't see me, chopping onions or whatever to pretend I was working, and waited for him to sit down. When his food was ready, I slid over to the cashier that was supposed to take it to him and said, "Don't worry, I got this." I walked towards him, unable to control my smile, and just before I got into his view, he was facing away from the counter. I said, "Hey man, is your back okay?" He was confused. "What? Perfectly fine. Why?" I put his food down with a smile and said, "Gotcha beach." His look of confusion morphed into surprised recognition and he goes, "Wait, I know you now," as I walked back to the counter laughing. He left immediately. I told my older brother about it later that day, and he said I should have recorded it. I felt stupid for not recording it, but still happy that I found him out. I occasionally represent insurance companies when they are sued by other drivers after a claim is denied. Usually the litigation is pretty subdued and predictable, but I had a recent case that was completely ridiculous. Insured driver, car A, bumped into another driver, car B, in front of them at a stoplight. According to the investigator, it sounds like car A just let off the brakes and rolled forward at idle about 5 feet before contacting B. With the way cars are built today, A was a large SUV, B a small sedan. Even a low speed collision can cause decent damage. Right away, the file seemed strange. Car A had admitted fault pretty much immediately and had maintained that he was at fault throughout the investigation process. For reference, I'd say 80-90% of the cases I work deal with contested fault point, so I start digging deeper into the claim. Turns out driver A stated there were 4 people in car B, while driver B filed a claim alleging medical expenses for 7 people. The insurance company denied the claim because car B only had 4 seat belts. Call to plaintiff's counsel went like this: where was person 1 sitting? Driver's seat. Person 2, front. Passenger. Person 3, passenger. Rear. Person 4, driver. Side rear. Person 5, rear. Center. My Records indicate that your client's vehicle doesn't have a middle rear seat. Ah, well I'll have to confirm that. Okay, what about person 6? Ah, passenger side rear. What about person 3? Ah, well, also passenger side rear. That case was dismissed pretty quickly. The clients ended up finding another lawyer, and they sued 3 separate times. The last time, we successfully argued that the complaint should be dismissed with prejudice, and the judge warned plaintiff's counsel that further suits would result in sanctions. Now, but when I was younger I was interested in working as a juvenile officer for a circuit court. Got to know the judge, and was invited to sit with officers of the court. One Tuesday morning. First case was a nasty custody hearing. Ex-wife accusing ex-husband of doing heinous shit with the kids. I'm talking borderline Jeffrey Dahmer meets the blue light bandit stuff that any normal human would pass off as delusional. But it's family court, and the court still has the duty to weigh in any evidence, etc. Basically she wanted full custody, alimony, thousands in child support, pretty much everything that should have been taken care of, or at least mentioned a couple months earlier during the actual divorce. In Idaho, it's about 0915, and the plaintiff is nowhere in sight. Her counsel requests to approach the bench, tells the judge that his client is indisposed. No good. Judge wants to know exactly what's going on, and tells counsel to spit it out. Your Honor, my client was convicted yesterday in XXXXX county of manufacturing and possession and child endangerment. All this over a hot mic. About half the courtroom broke out in laughter. Judge shushes everyone and says to the plaintiff's attorney, if only they were all this easy. I think you know how this movie ends. Case dismissed. Get out of my courtroom. Now. Not a lawyer, but I did just have a proper Phoenix Wright moment. Long story short, the mother of my kids and I had been arguing for a long time, for a couple of years. During all of the pre-trial bit of my story, my kids are safely away at their grandparents' home, far from this insanity. So one morning, after staying out all night with one of her friends drinking and no communication, turned her phone off, she knocks at my door. House is 100% mine for unrelated reasons, and says, you ready to talk, or are you gonna be a little kid? Our last argument in my house erupted, and she went hysterical, screaming loudly at me, pushing, hitting, and slapping me. I pick her to get her to leave, and hopefully calm down, then come back to have an adult conversation. She leaves and I didn't hear from her the rest of the day. The next day, I'm sitting in my chair playing Ghost of Tsushima when I hear a knock. It's the police. They tell me they are there to issue me an EPO and award temporary custody to their mother because I beat the mother and crushed her and said I wanted to kill myself. OBV depression related stuff that I opened up to her years ago about, but is not applicable anymore. Fast forward 2 weeks, and during that skip, almost everyone at work, we work in the same place, looks at me with disgust. She spread her lie to our workplace. When our court date arrives she requests more time and pushes the court date and EPO out for an entire month. My hold it moment is approaching, I promise. Finally our court date arrives. Her attorney pampers her with questions, letting her answer about how mean I was and how I beat her. Lies. Then she asked her about the morning or our last argument. My kid's mother lies and says she showed up to the house. I immediately question her, and when she tries to get her stuff, I picked her up and crushed her and threw her out the door. Same lie I heard at work. My attorney goes next. First question, how would you describe the initial altercation that took place that day? Mostly verbal. Verbal how? You are aware of my client's security cameras, right? This was all digital because of COVID, but the look on her face was priceless. The judge was dumbfounded when he saw the truth, that she was the aggressor, and even said in his closing statement, if I pressed charges it would be the easiest slam dunk he's ever presided over. I turned it down and said I just want to see my kids. Thanks for reading. Edit. Spelling. I was prosecuting a guy for possession of marijuana with intent to deliver. Yeah. I live in one of the last states not to legalize it in any form. Bite me. Anyway, the entire trial centered around 2 questions. 1. Was the pot his? And 2. What did he intend to do with it? For the first question, the fuck yeah moment came when I won a motion to introduce the officer's body cam video of him talking with the defendant while he was in jail about the charges. The defendant was trying to argue that the pot found in a black bag wasn't even his, even claiming that he had no idea where it was found or what it was found in. But then he threw out this gem. Answer me this, you dumb son of a bitch. Where'd you find that black bag? Yeah, the jury loved that sheet. He also called the cop a retard earlier in the video, so that was a nice bonus. On the second question, we had testimony from some co-defendants we flipped that he was decarboxylizing, basically, half baking, the raw marijuana he'd brought to the house in the stove when the cops showed up to do a welfare check on the kids at the house. But they had found the pot in a bowl in a back room, not in the oven, and these co-defendants weren't exactly Mother Teresa. The oh shit, would ya look at that moment came when I pulled the gallon bag of pot out of the evidence bag, and it was partly moldy, which meant that the cops had interrupted the dude's half baking, leading to a bunch of moisture remaining in the half-baked marijuana, which supported that he was, indeed, baking it when they showed up, and interrupted the process. Yeah, I won that trial, and it survived multiple appeals. Not a courtroom, but back when I was studying law at university we would do practice trials as competitions. We referred to them as moots, not sure how they are referred to elsewhere. We were to defend a fictional case, man who had a series of events between him and his wife, infidelity, kicked out of house, denied access to children, accused of crimes, etc. that culminated in him killing his ex and her new partner when he caught them in bed. The point was not whether we agreed, but to demonstrate correct use and interpretation of the law. Using the Coroners and Justice Act 2009 we argued that whilst infidelity wasn't able to be used as a defense of murder and the notion of loss of control, it is unfair to discard it entirely from the timeline of events which, like I said, included being excluded unfairly from his own children and other distressing things. Our opponent brought up the history of the law, saying that loss of control was made to help women who were abused, and was to understand why they killed their husbands after years of abuse, which clearly didn't apply here. I was studying for my dissertation on domestic abuse laws at the time, so was well aware of the history, but noted her misapplication. In response I stood up and stated that whilst my learned friend was correct on the history, excluding our client from the defense was at best a misguided conflation of the legal text and its history, and at worst an act of sexist discrimination not supported by the text. Her jaw hit the floor and we won the contest. Not a lawyer, but signed a lease on a new place in a large city as soon as it was on the market because renting can be very competitive here. There were a lot of small repairs to be made as the previous tenant lived there a decade, but there was 2 months before move-in, and I got everything in writing that the repairs would be made and the place would be repainted. Move-in day comes and the apartment looks just as I saw it 2 months ago. Called management and they told me to move in and they would fix everything afterwards. I was not going to pay for an unfinished apartment and have maintenance come into my home every day during a pandemic. Informed management I would like out of the lease. Was snarkily told I would be responsible for finding a subtenant. Informed them they would be hearing from my lawyer. My lawyer claimed he had an ace up his sleeve, but from what I understood of this city's laws was the landlord had 2 weeks to make things right and that there was a lot of grey area for what making things right meant. I sent my lawyer an itemized list of 20 plus things out of order and he CC'd me in an email to management stating the lease was invalid as they failed to provide me the 2020 tenants' rights document required as a part of all leases in this particular city. Lease was void. They kept calling me saying the apartment would be ready in 48 hours and I wouldn't have to go through the process of finding a new place, but I said no thank you, and now that place is still on the market for hundreds of dollars less a month than I was originally going to pay. Now but a good story. My husband was going to adopt our daughter. Dad had been absent for years, but thanks to due process we had to notify him of adoption. His family pushed him to contest. First hearing, it's me, my husband and my attorney, all of us in nice suits, and the judge, who worked with my attorney all the time, and in strolls Dad with no attorney looking like he rolled out of bed, no tie, rumpled shirt and pants with a smug smile on his face. When it came time for him to speak to the judge, he tell judge he's contesting. Judge looks around for BO Dad's lawyer, then asks, are you representing yourself? BO Dad respond, no, I'm going to get an attorney. All of us look at each other. He knew 4 months before the court date. So the judge says, but you don't have one yet. No, I'm signing with her today. I have her phone number, and she asked that you call her to set up the next court date. Judge asks BO Dad attorney's name. BO Dad has no clue. Our attorney gave the name to the judge based on googling the phone number while we were sitting in court. Judge glares at BO Dad, shakes his head and walks in the back with our attorney to set up next court date. When judge and our attorney come back into court, our attorney is trying very hard not to laugh. Judge rips apart my BO Dad, stating the next time he comes to court for a continuance and doesn't even have the attorney on retainer and disrespecting his time, he is going to throw him out of the courtroom. Bear in mind this judge will be making the adoption ruling. After we left court, our attorney said that the judge yelled at the opposing counsel since she was uncooperative with setting up a new court date and let it slip she hadn't even been retained yet. Plus, judge and our counsel had no idea who this other attorney was. In a smaller city everyone know everyone in the court system, so that was a plus, since judge worked with and liked our attorney. To boot, the judge was ranting about BO Dad being unprepared and wasting everyone's time. We left court with smiles, pissing off the judge. The first time you meet with him, not gonna win you a case. Representing parents in child protection cases is very hard once the authorities have decided to take the children into permanent care. Usually the best hope is to find a relative to take the children into their custody. But I have 1 such cases for parents. In one, a family support worker who had been working with my client, the mother, said she was making progress, but he was abruptly suspended after another client accused him of being sexually inappropriate. That's not the issue. Even the agency admitted the allegations were unfounded, but their policy was that they had to suspend him while it was investigated. The issue was that they didn't appoint another family support worker for my client in his place and just cut her loose. That was a case where I had thought my client had no hope of getting her kids back. As soon as I heard that, I knew we had something to work with, because the agency had just given up on her, contrary to the legislation which says taking away children permanently is only a last resort. The kids are still with her today. I later represented her to get child support from the scumbag father in the other case I won. My client was a father who'd had some drug issues in the past, but had gotten clean and was working as a cook in a local restaurant. The agency tried to use his work schedule against him, on the premise that he worked too much to look after the kids. The judge was pretty incredulous about that one. I was a defense attorney on a murder case of a store clerk in Alabama. Due to circumstantial evidence and a false confession to an unrelated shoplifting charge, my 2 clients were misconstrued as the perpetrators, and one was charged with first-degree murder, and the other as an accessory. I used my knowledge of the cooking time of grits to force the first witness to admit that his perception of time may have been inaccurate, meaning he could not corroborate the prosecution's timeline. I was able to discredit the next 2 witnesses by questioning their ability to make a positive identification due to obstructions in their sightline and impaired vision. But it wasn't until the 3rd day of trial, when the prosecutor produced a surprise witness, that I had that aha moment. The new witness testified that the pattern and chemical analysis of the tire marks left at the crime scene are identical to the tires on my client's book. But one of the photos that my girlfriend took at the crime scene held the key to the case. The flat and even tire marks going over the curb revealed that my client's car could not have been used for the getaway. I had my girlfriend testify as an expert witness because she has an encyclopedic knowledge of cars. She testified that only a car with an independent rear suspension and posse traction could have made the tire marks, which ruled out my client's 1964 Buick Skylark. One model of car with these features is the similar looking 1963 Pontiac Tempest. We then recalled the local sheriff, who testified that 2 men who fit my client's descriptions were just arrested in Georgia for driving a stolen Pontiac Tempest and were in possession of a gun of the same caliber as that used to kill the clerk. Obligatory, not a lawyer. Got pulled over at 17 for a busted taillight. Cop caught a glimpse of a broken butterfly knife in my backseat and pulled my buddy and I out of the car and cuffed us. Found a single, warm, unopened can of Bud Light under the passenger seat buried beneath 2 weeks of dirty clothes and fast foods trash. My buddy swore up and down it was his beer, but in Missouri the driver is responsible for anything in the vehicle. Ticketed for broken taillight, minor in possession of alcohol, dangerous and concealed weapon, and no field sobriety test, no breathalyzer, was never even asked. If I'd been drinking point car towed, bring us to the station and book us. I finally get searched. Different cop pulls a rubber out of my pocket and cracks wise drunk and lucky. MF I ain't lucky standing here talking to you when I should be getting some pussy, and if I were drunk this would be a lot funnier. Cue several looks around the room and a baffled me, just now realizing I was brought in for a drunk tank 24H hold point has me do the stand on 1 foot and count shtick, passed with flying colors, takes the cuffs off, look up touch your nose sheet. Cue me I leave and blow for you. Goer and fucking tea I'm sober mean Willie a friend has decided he's not going to let us sit in holding all night and is trying to bail us out, drunk and high standing at the front desk at 3:30 in the morning. Alternative helicop that brought us in tears up a couple of my tickets and they never see the light of a courtroom. We get released at 2:45 the next morning and can't get my car out of impound, so I go home to wait and call my lawyer in the morning. At discovery, the dangerous and concealed weapon charge gets brought up. I had informed my lawyer the knife was broken and wouldn't function as designed, so with the prosecution's permission he took the knife and flipped it open. The whole thing fell apart. Class C felony thrown out. Broken taillight. Reduced to loud muffler. Minor in possession. Had to pay $250. Never had to set foot in a courtroom. Represented myself on a charge of assault. Short story, mistaken identity. At a hotel during a big festival waiting for a food delivery in lobby, Chinese. Cops come in, and this delivery guy, pizza, points at me and exclaims that's him. Arrested, accused of spitting on pizza guy and demanding his pizza. Made bail, issued promise to appear on certain date and time. Tradition is on date you appear 15 minutes before time, meet with Crown at an OI, and negotiate plea to less or charge your fine/sentence. I did not do this meeting though I was in court at the promised time. I sat in the galley from 9 AM to about 3:30 PM. At end of day judge announces intent to adjourn for day and asks is there anyone within the room that has unfinished business. I stand say yes, I'm Wasusatobe, number 7 on the docket. I have not been called to appear by the Crown. Sit back down. Crown at an OI looks back says why didn't you meet? I saw you this morning. I thought you were a law student the way I dressed, and the legal pad, if paper I carried, fake note taking etc. Judge, Clark. Clark calling number 7 on the docket, calls my name. I stand saying I'm he. Judge asks how do you plea? Me not guilty point judge. To Crown what evidence for prosecution do you offer? Crown, the Crown offers no evidence. Judge to me, you are free to go. 5-second stare from judge towards Crown. Gotcha usually end of date question has Crown reading off fail. To appear persons with guilty verdicts automatic and arrest warrants issued. This one is a doozy. An embezzling finance director's ML account was provided to us by court order, as were the officers and directors involved in the theft. This included all records and acts. They had deleted thousands of records and thought they were clean. Then 2 bombshells hit Point Dropbox Emerald stating the company account went unpaid. We paid it and opened it up, not knowing it existed. Inside was the other side's entire case worth of organized books and records, all evidence to defend our state and federal suits, in exhibit format. Point everything they had, and prepared to use, was officially ours to access as it was in the company accounts, per the order. Inside were all the uncooked books, and records in the falsified books, and records they were going to use in court. Dropbox recorded 4,700 deletions including who, what, and when. Then the IT officer sent us the logins to the company meeting and project management systems, and inside were 20 hours of recorded meetings regarding the theft and the entire operation scheduled out in Trello showing every who, what and when of the illegal activity. Victory was assured, or do one would think. Shortly after, we delivered it all as part of a 10,000 document discovery, which I had saved as PDF files, to force them to open each one with great patience. 4 days later all 5 parties falsely claimed to be owed money and the state put the company into involuntary bankruptcy, sucking in the suits with it. The company was under their operational control and they didn't fight it as it was their action. The bankruptcy trustee refused to consider any evidence of fraud and sold off everything to the highest bidder, the thieves themselves. This despite the court finding those involved responsible for the wrongdoing. Oh, and then there was the time the defendant took his personal laptop to work to steal company trade secrets and was caught, sued, and just before court 1,200 images of horrendous child porn was found in the backups he made on his work machine. They settled 2 days after we notified their lawyers that he was indicted and they should talk to their client as he was just finding out himself. This will get buried. Many years ago I worked retail fraud for a retailer. The guy I ended up stopping stole 2 cans of paint from one store about 15 minutes away. The retail fraud guys couldn't catch him before he left the store, so they gave me a description. He then came to our store to return without a receipt. At the time returns under $50 were allowed by corporate policy. As soon as the return is completed, I arrest him. He fought, but I wrestled in high school, so I took him down, got top control, and cuffed him. A month later, I go to court along with the retail fraud people from the other store. They testified that he walked in, grabbed 2 cans of paint, then strolled on out of the garden area. I testified that they called me. They gave me his description, including his physical appearance and clothing matching exactly, including a unique t-shirt. Against the advice of his court-appointed attorney, he takes the stand. The prosecutor starts asking him questions. He asked if he stole the paint. Guy denies. He asked if he's ever stolen paint. Guy denies he was even at the other store. He was asked if he's ever been caught stealing from any of our stores. Guy denies once again. Prosecutor asks him if he's sure. Guy says yes. At that point, the prosecutor is able to refute this by bringing in his extensive criminal history for theft, including prior arrests at our other stores. Guilty. Dude served 9 months he would have lost if he hadn't taken the stand, but he ended up getting much more time because he insisted on taking the stand. Not a lawyer, but I had a really facky one happen to me I figure would be good to share. So a few years ago I was charged with attempted manslaughter because when I moved out of my abusive ex's house, she claimed I had stolen her glucometer. She was type 1 diabetic. Now for a flashback in the middle. Don't worry, we'll pick up what happened in a bit. When I moved out, I packed all my shit into my tiny little Honda CRZ. I drove 2 cities over and parked on top of a parking garage to sleep. I had to leave at 4 AM to avoid her. Well, she called the cops and my parents at about 5 AM when she realized I was gone, telling them I stole her pain and sleep pills. She wasn't prescribed any, nor did she have any, and went to city to commit suicide. Cops show up, find me asleep on top of the parking garage, and smash my window because they think I'm overdosing. After a shocked exchange of words, they then take a full inventory of my car because I was reported to have stolen the pills. To no one's surprise, no pills were found. Now back to the main story. So my ex had gone into ketoacidosis for not maintaining her diabetes, and in the hospital, told the doctor she wasn't checking her levels because her glucometer was stolen by me. He said to press charges, and next thing you know detectives are picking me up and bringing me in. They arrested me on just the hearsay from my ex, and I went before the judge and DA. After a while of discussing things with them, they finally find out I had no contact with her for the past 6 months, and I had also gotten my car inventory taken by the police the same night I left. Case was thrown out, and records of the arrest were expunged. Now it's just a story of the time my abusive ex managed to keep abusing me months after I thought I escaped. TLDR, abusive ex says I tried to kill them months after I left. Cops cleared the case with their own records from prior interaction. My client Peter was a partner who founded a small business with defendant Denny. They had no formal ownership agreement. The business starts to take off. Denny's mother convinces him to cut out Peter so she can be his partner. Denny does just that. We sue Denny and mother. mother and Denny claim over and over that Peter is an employee who is lying about his role and is owed nothing. Denny didn't know we had a letter he wrote to a customer calling Peter a partner. This is how Denny's deposition went. Covered mundane topics to lull him into a sense of complacency. Mr. Denny, did you ever write any letters calling Peter your partner? No. Absolutely not. He was my employee, that's it. Let me show you exhibit 15, a letter you wrote a year ago. You call Peter your partner amongst other things. Did you write this letter? Oh no, I didn't write this. It's that your signature at the bottom. Yes. And your letterhead. Yes. How do you explain this letter? Are you claiming it is a forgery or a fake? The text inside is fake, but the rest of it is real. How so? Well, I keep preprinted stationery in my desk and Peter must have obtained some. Why? Is your signature also included? My preprinted stationery also includes my signature at the bottom. So you have preprinted, pre-signed stationery. How do you fit the words in between? Denny is starting to sweat. It's just more convenient that way. What do you do if you write more or less than one page? How do you always get the spacing right? Denny is sweating bullets. His counsel calls for a break. The settlement comes shortly after. Later on, the business hits the stratosphere. A year later, Denny is dramatically assassinated. I can't provide any further details. Not a lawyer, but did forensics on a discovery case. Recovered a lot of deleted documents, request of opposing counsel, which are often only partial files, and not easily opened. Additionally, they provided some very vague search terms to produce all hits on, which resulted in a very full DVD of mostly partial files. Opposing counsel demanded we have an in-person meeting to discuss the production, which included tens of gigs of spreadsheets and Word docs. Lawyer claimed we were just trying to bury the evidence. After we explained how search terms worked, he continued to get upset about corrupt documents and fake data that couldn't be opened. He asked how to open a Word document, and my boss, who was not tech savvy, double-clicked on the icon, and it opened with no problem. I nearly died on the spot. He then gave a specific Bates number for a document he couldn't open, and claimed it didn't hit on a search term because it couldn't be opened. He asked me to prove it hit on the search term. Before handing me his laptop, he warned I use Ubuntu, so you may not know how to use it. Restraining an evil laugh, I opened a terminal, ran a grep, and showed all the locations in the file the search terms matched. We left the law office, had a big old chuckle about the matter back at our office, and enjoyed some cookies with the client. They dropped the case the next day. Not a lawyer, but a pair of court hearings. Me defendant, plaintiff. Well, truly sad case, but bit story time. So, plaintiff, she had been a friend of many years, but alas, her mental health went very seriously bad/wrong. We are talking Black Ops military attack helicopter landing on her rooftop wrong, in a densely populated urban area, except only she saw and heard this helicopter. Because it wasn't there, that was the reality, but only in her head. So, plaintiff, psychotic, delusional disorder, persecutory subtype, but undiagnosed. She refused treatment. She almost got 5150 ed, but narrowly missed/escaped that, but matched criteria plain as day, was almost word for word matched to defining descriptions. But that's mostly just backstory. So, we bit more intro, then on to hearings. So, she was delusional, believed some vast powerful person at the head of this giant powerful international conspiracy had nothing better to do with all those resources than to ruin her life and reputation. And she was always highly convinced who headed this conspiracy, but would periodically change who she was sure headed this vast powerful international conspiracy against her. Oh, and her delusions and messed up head. Not only way messed up with what she believed, the reality in her head, but not beyond, but also seriously mucked with her memories. They would not only radically change in interpretation, but then even basic facts would change, and then quite beyond that to things happening that didn't, or not happening that did. It was one hell of a mess. So, then it was my turn. She suddenly believed I was the head of this vast powerful international conspiracy against her, and to destroy her life and reputation. And she took legal action. Filed for restraining order, blah, blah, blah. She got the temporary restraining order, true, but that's quite easy to get and uncontested. One party fills out paperwork, claims under penalty of perjury it's true, judge looks it over, and it's typically quickly granted. Well, of course I challenged and defend against it. And I was prepared, well prepared, even quite over prepared. Civil, I thought it was preponderance, but no, restraining order, clear and convincing evidence. Well, of course, everything she claimed that would have been of any relevance was total bull, but she believed it was true, cause that's where her head was at. Much of it was he said, she said, so nothing to easily sort those bits out, other than lots of context and background and other general clues/evidence. But she also put down something which was absolutely not a he said, she said, and would have been trivial for her to prove, or at least provide substantial evidence of were it true, and a serious allegation at that. So, notably among other bits, I quite seriously attacked on that point, and her lack of credibility as a witness. That it ought be easy for her to provide evidence if that allegation were true, yet she could provide, and had provided exactly zero evidence of the allegation. Then judge not only picked up on that, but what was your hold it moment where you knew you would win? Key bit judge picked up on early on. We'd been friends for about 20 plus years. And before, and even right before she accused her blame of the conspiracy theory to me as heading it, who did she run to for extensive help? Me. So, yeah, the judge just wasn't buying it. And, in addition to that, her stories just were not holding together. They were grossly inconsistent. The more she opened her mouth and testified and presented evidence, including lots of written/printed evidence, the more she self-destructed her own case and arguments. So the more evidence she gave/presented, the stronger she made my case. Mostly all I needed to do was sit back and watch her self-destruct her own case. And, I didn't even pick up on it till later, when I read the transcript, but I also noticed the judge's questioning of her. It quickly went from questions about what did/didn't happen, to, as he realized her worldview didn't match the rest of the world, what, in your world view? His questions were very much like that. After getting a moderate bit into it, and seeing rather clearly what was going on, and what the situation was, yes, it was summarily dismissed. Round 2. She filed likewise again. This time she didn't even get a tro. Not that she didn't try, but with her claims going even further off the rails, and perhaps also with the earlier dismissal, no tro was granted, but still hearing, etc. Well, different judge, but things went relatively similar again. Though different judge, in the interim, both she and I had appeared before that judge fairly recently. She'd advanced to making credible death threats against me. I filed restraining order against her. Even family members of hers were urging/suggesting I file a restraining order against her. Difficult decision, but I did file for restraining order. So, anyway, this judge had seen us once before, and was somewhat familiar with the goings on. Judge should have gotten copy of the earlier case materials from when she'd prior filed for restraining order, but there was a procedural boo-boo and the judge didn't have those materials. Judge was annoyed at that. I did also have transcript from that earlier hearing, and offered it to judge, but judge proceeded without, and worked with what evidence was being presented/offered on the current hearing, and some information of what happened on the earlier, including my and plaintiff's statements, etc. What was your hold it moment where you knew you would win? And yes, it was, at least functionally, much of the same again. Sadly, but fortunately, every time she opened her mouth or submitted evidence, she just tore down her own case, and any pretense of credibility whatsoever. So, yeah, again, mostly all I needed to do was sit back and watch her self-destruct her own case. And in quite quick order, judge not only dismissed the case, but had it dismissed with prejudice. That basically means we're done here. This is decided. You can't file this again, as it was mostly the same again, though there were various allegations, and those were moderately different. It was mostly the same again. A bunch of baseless untrue allegations with no evidence to support them. So, dismissed with prejudice. And at least thus far, knock on wood, that's been it since then. Not a lawyer, but our landlord is an extremely narcissistic person who has massive bipolar issues. All year she has given us extremely bad house tenant reports after inspections, even though the house was a-okay. She would come into the house at random times and abuse the hell out of us. She would bring her young kids with her, so we would feel bad retaliating back. So she wanted us to pay for a brand new kitchen bench top because there was a small chip in the 12-year-old bench the size of a peanut. And the whole thing is going to cost $4,500. So I called up tenant rights places and all of them ask me if the bond money has been lodged through the government. I checked the database and the money wasn't there. Mind you, if the landlord hasn't lodged the bond, then it's a $5,000 fine. I thought that was strange, so I texted her for the bond number and she gave it to me the day after. Then I looked in the database and the bond was lodged on today's date. If she's gonna continue to stuff us over with that bench top, guess who's gonna get a massive fine? TLDR, my landlord is a complete nutcase. She's forcing us to pay $4.5k for a new kitchen bench top. She's dodgy with the bond money. She's getting a massive fine. Not a lawyer, but our gazebo was set on fire deliberately by our neighbor's friend, whom he hired for $200 to do so. The neighbor of Fizz overheard them devise the plan from her yard. The night that it happened, I woke up. Because my baby needed to be fed, I sat in the chair in the living room, and there was a fire-like type of light coming from the back door. I thought maybe my husband was out on the deck using our propane fireball. But it kept getting brighter and brighter. I get up and look out the door, and our entire gazebo was up in flames. And I scream for my husband to wake up, and he doesn't even think. He just goes outside, puts it out, and he hears a voice while he is calling the cops. The loser who did it says, "I'm just taking a pee." And my husband says, "Can I help you?" The guy takes off, and my husband jumps the deck after him, and he doesn't get far before my husband catches him and hauls him back to the house to wait for the police. The guy had a lighter and a gas can in his hand. He also tried to light our truck on fire too. It was a open and shut case. The cops saw the evidence and the fact he had the stuff in his hand. He is serving a year in jail, and his buddy that paid him has a Canada-wide warrant he took off, and I really wish we knew he had one out for him before he moved. I was at trial in a lemon law case. One of several themes of the case was that the mechanics who worked on the vehicle were basically incompetent and unwilling to perform any work. I framed them as basically testers who would run computer tests, find nothing, and give the car back. The paralegals who drafted the trial subpoenas mistakenly listed each mechanic who worked on the car as a percipient witness, meaning that they were only there to testify as to what they remembered, and not as a person most qualified to discuss the repairs that were actually made. As I came into the case late, I was not aware of this fact. The mechanics were set to go on next as hostile witnesses, and the judge gave us a 15-minute break to let the defense get the 3 mechanics on deck to testify. On their way out, one of the defense attorneys told me, quite satisfied with himself, that the mechanics were served as percipient witnesses, and thus were only going to testify as to what they remembered, which is lawyer for we coached them not to remember anything. Have fun on your direct. Just before I went to do the first direct, I leaned into my co-counsel and told him I don't want them to know anything. Watch this. Each mechanic was called to testify separately so that none of them would hear the testimony of the other. After a few questions confirming that they worked on the car and their assurances that they didn't remember anything from 3 years ago, I started to ask them general questions about what they did. I used to work on cars growing up, so was more than familiar with the terminology and procedures for inspection and repair that the mechanics had done on the vehicle. I had each of them so confused that one of them couldn't even tell me whether he ever did an oil change at his job generally. Another one couldn't remember if he ever changed a spark plug in general. The jury couldn't believe it. I had them describe in detail the machine they hooked up to the car, but they couldn't tell me whether they actually inspected the vehicle based on my client's description of the problems, in spite of there being no codes. The last mechanic said that he didn't think they inspected it after no codes showed up. The look on the defense attorney's face was priceless. They didn't even bother with follow-up questions. The jury deliberated for 30 minutes into their lunch break before asking the judge if there was any way they could award more damages to my client. I'm not an attorney, but served as a juror. The case was a kind of stalking case about a couple of neighbors where one was low-key intimidating the other. The stalker had what I assume was a pal of his as his counsel. The guy was clearly not a trial lawyer. A city attorney was prosecuting the matter, assisted by a younger attorney. So, the restraining order in question required the defendant to stay 100 yards from the victim at all times. Obviously, this is the USA and the defendant was 60-ish years old. So when stalker guy took the stand in his own defense lawyer / pal led him through some anodyne questions. One of the questions led the defendant to claim that he had never seen a football field in America. After 60 years here. As a stalker answered that question, you could see the city attorney practically jump out of his chair, grabbing his notepad and scribbling furiously. I'm sure he could also see that most of us in the jury box were also reacting unfavorably to the defendant. Naturally, when the cross-examination arrived, the prosecutor jumped up and asked the defendant if he was sure he'd never seen a football field. Yes, he was sure. Prosecutor asked if the defendant had attended junior and senior high in the USA. Yes, he had. Had never seen a football game in TV. No sir, never. I swear, the city attorney tried very hard to not strut back to his desk. He didn't really succeed. After the jury spent about 5 minutes completing our verdict, guilty, the jurors don't like people who obviously lie, and the other testimony didn't help him. The city attorney offered to debrief with any jurors. So 5 of the 12 stopped by to talk with him outside the courtroom. We asked him about that football field testimony. He got a big smile on his face and said, yeah, that was an easy opportunity. My wife and I helped a neighbor move out of her abusive husband's house, and she stayed in our spare bedroom for a while. 2 weeks after she moved out, her daughter, 16, wanted out too. We took her in, but the husband went on a rampage. He attacked my wife and I intervened. He hit me with brass knuckles repeatedly, and I started laughing at him. He said, "What are you gonna do, Beach?" I said, "I'm gonna take it and laugh at you." I went full Tyler Durden laughing at him as he punched me 6 or 7 more times. Long story short, I got a disturbing the peace charge. He did too, and instead of pleading for a lesser charge, I decided to defend myself in court. Court day comes, and the prosecutor has the asshole's sister as a witness. Asshole didn't show up. The prosecutor starts and asks what she saw, heard, what I did, etc. I asked my questions and she gave her bullshit answers. Her answers changed every time I rephrased my questions. I asked her why her answers changed, and she stumbled. During the judge's deliberation, she says clearly the witness was lying to protect her brother, so I'm going to disregard her entire testimony. I'm thinking, isn't perjury a crime? But the charges were dropped, and the prosecutor came over and shook my hand. He was so happy I was able to defend myself. It was weird. This guy was my enemy 1 minute, but when the judge dropped the charges he was all smiles and friendly. Amazing. I was doing spray foam insulation work. I was the installer, my boss and I, and went through the courses to be certified in this field. So I knew that if something was wrong, that I was to halt whatever I was doing until it was made right. Anyway, the diaphragm was not closing on my fresh air respirator. My boss told me to just switch it with one of the other ones from somebody else's mask. The job had to get done. Those were his words. Being that it was a fresh air system, the air was coming from outside the house into my mask, so I did not realize that the diaphragm was not closing. Whenever I would exhale, it would blow out any air from my lungs, and then inhale. I was inhaling the fresh air from outside as well as the contaminated air from underneath the house. But what I did not realize is that the fresh air was masking the smell that you would normally smell with the contaminated air coming into my mask. For 2 days I was underneath this house spraying the foundation. The 3rd day that I was supposed to go up there and finish up, clean up and roll up, I was too sick to even get out of bed. I called my boss and told him I couldn't come to work, and he freaked out, like, "You have to go to work, this has to get done, blah blah blah." I told him I was going to the emergency room, and that's when his tone changed. I said, "I've been overexposed to the fumes from the spray foam and I don't even have enough energy to get out of bed." He came over and talked me out of going to the hospital. He said, "Just give it a day or two. It's like I'm your friend, come outside with me." I said, "I can't come outside with you." I don't have enough energy cause you might have to help me back in here anyway, so when I should have went to the hospital and then I should have gotten a lawyer. I did not do any of these. I was in bed for 6 months before a friend came over and introduced me to some of these natural remedies for breathing and got me back on my feet. I lost a lot out of that and I could have gained a lot out of the lawsuit, but this was over 7 years ago, which I believe is a statute of limitations. I don't know. Yes, for a response here you go.